mark everything up, and they'll send it back to the provider. What do you think the reaction is of the provider rep when they get that contract all marked up in red? Somehow it's going to fall pretty low down in their priority list of contracts to tend to. Think about it from the provider rep's perspective. I don't know if they have a volume or incentive compensation tied to how many contracts they get through, but certainly if they are being monitored about whether they are forming a network with enough providers, and they're going to start with the easy one, those providers that just sign the contract or have a couple of issues in their contract. They're probably not going to pay attention to those that have tons of issues in their contract, because now you're sort of pigeonholed as a problem provider. So you may not get the attention that you think you deserve. There's another problem with that process as well, which is, let's say you make 50 proposed changes and they give you 25 of them, and then they send it back to you and you say, well, those aren't good enough for me. The plan's going to say, we gave you half the changes you want. Why isn't that good enough? It's not the plan's fault that you didn't identify which were the most important changes and have them, at the start of your negotiations. Maybe the plan agreed to all the easy stuff. Didn't really get you that far in the process. It's very helpful for you to prioritize what you want changed at the outset and start with the highest priority issues. So that means that internal contracts team that we discussed at the outset, have that team internally work through all the issues in the contract and prioritize. Find 5 to 10 issues that we really want to have changed in the contract or negotiate, and make that your strategy. Because obviously, if you can't get through those issues successfully, it doesn't matter what you do on the easy stuff, because they don't matter as much. You want to start on the real, I don't know if I want to call it make or break issues, but the key issues that will affect your organization. So, take a highlighter, categorize all those in red that are really the most important issues to negotiate, because you don't want to proceed because of the risk to your organization. Color some yellow for creating some risk, but not the highest priority is red, and then mark some in green, changes that you'd like, but are not essential for you to participate in the contract. And if you go through the process and all of them are red, you've done it wrong. You have to go back and do it again, so that you are clear internally as well about which are the key issues. And there might be some debate. I mean, your CFO might have a different opinion than your COO or whatnot, and you should resolve those issues internally so that you have a sort of united front about what the key issues are that you want to negotiate when you get to that stage with the MCOs. We have a bad reputation, I think, about what negotiation entails, because we've had very poor models, I think, over the years for what negotiation is. Many of us think of negotiation as somehow like a battle. We have to bully the other side into submission. Not a good model of negotiation. Don't try to copy the executive branch in our current federal government and Congress as a model of negotiation. Not. Reframe negotiations. So my mantra is encouraging you to think about negotiation differently, because many of us don't have a lot of practice with it. There's a couple of cases, I think, that we negotiate as consumers in this country. When we buy a car and when we buy a house. But outside of that, most of us don't haggle for the price of our grocery store. Groceries. We just pay what the sticker price is, because, of course, the grocery store clerk would be a little bit confounded if you try to negotiate for the cost of an apple as you move the checkout line. So we just don't have a lot of experience doing it. So I say, think about negotiation not as a dispute, not angry, not kind of a bullying scenario, but really just a conversation aiming to reach agreement. And to me, that fits in a lot more with your philosophy, probably, and generally for how you'd want to negotiate something collaboratively with a partner. Because remember, you're going to be stuck with the MCO at the end of the day. In any negotiation, if you're going to be stuck with the other party, then don't you want to have sort of a good feeling on both sides? Otherwise, a party that resents you from the negotiation process may not be very happy to work with you collaboratively in the future. So I think the ideal circumstance is that you have a principled discussion and negotiation and achieve an outcome that both parties are satisfied with. So how do you get there? Let's talk first logistics. Logistics means who's negotiating and how. So as I mentioned earlier, try to find 1 or 2 people top that will be representing your agency, your organization in the negotiation. Do not make the mistake of having your entire team on the conference call with the plan. Why? Many of you have ever had a job interview where you have 7 or 8 people firing questions at you at one time. How comfortable did you feel? probably not too comfortable. The goal here is actually to make the MCO rep, sounds a little bit funny, but get the MCO rep to feel as comfortable as they can and not threatened. And if you have too many people outpowering them, even though they're part of a larger organization, the person might feel threatened. And they may not share things with you that would be critical and helpful in the negotiation process. You know, for example, that MCO rep that told me that they lost the only provider in their network for that service. Do I think she would have told me if we had 8 people on the call with her? Probably not. She might have, might have showed how helpful she would have been. So I always think you want a circumstance where you are encouraging the other party to speak, not discouraging. So 1, 2 people talk. What about how you negotiate? In writing, by email, back and forth, not a good idea. Have you ever had an argument, with a friend or a loved one by texting or email? How well does that go? Not good. You talk past each other. Email is a great device for setting up a conversation, setting an agenda for what you'd like to discuss, but not the actual. It's not a substitute for actual negotiation by telephone or in person. I have had some big health plans actually be willing to come and negotiate in person. Typically, when they want to get a contract done, the organization will then say, okay, well, why don't you come? And some of these reps will actually come around to the location to negotiate because they want to get the contract done. That's fantastic. That's an opportunity to show them who you are, who you serve, what you do. It makes a huge imprint and impression on them. That's ideal. But for most of us, it's not going to be in person. It's going to be by telephone instead. Many of us start out thinking for negotiations that the best way to negotiate is to take an extreme position and then work backwards from there. Now, that's a very common negotiating methodology. In my view, it's a terrible. Can I show my slide? Kid on it? Did I miss that? Where's my kid? Oh my goodness, it's out. It's not just my kid. I actually have a book that I recommend. I purposely didn't bring my book because of that. I'll have to insert the slide next. So the basis for negotiation that I prefer to use is a book called Getting to Yes. That was written by a couple of law professors from Harvard in the 70s. It's like in its 3rd reprint, and that's why I'm surprised I can't find the slide. Usually I share the slide and the citation. I'll have to insert it on the break. But it's a fantastic book because the principle of the book really is about having principled negotiation, where you don't bully the other side. The authors believe that you should be soft on the people, hard on the issue. And to me, that's a nice framework for negotiation. I've had many MCO reps that have said at the end of it, wow, that was the nicest negotiation that I've ever had. And my view is you don't have to be a jerk during negotiations to get the outcome that you want. In fact, many provider reps are beat up by providers and internally probably from their plans, and it's refreshing to them to actually have a nice person to negotiate and resolve issues through. So I think you can still be nice to the person, but still be significantly hard on the issues that you want to come out the right way, the terms of the contract. So in this book, they suggest that you have a principled negotiation where you really think about the interests behind the provision and then negotiate from there if the party has no interest. So one of the things they rail against is negotiating just over positions, where one party takes an extreme position and then neither wants to kind of like give up or give a little bit in that process. They give this example, the story in the book, where they have a librarian, and the librarian sees 2 patrons arguing about how open a window has to be. One patron wants the window open all the way, and the other patron wants it closed, and all you see is them going back and forth, and even in the middle, it doesn't seem to satisfy them. Now they're making a ruckus, so the librarian goes over, and she says to one, why do you want the window open? And he says, well, because it's really stuffy in here, I need air. And she says to the other, why do you need it closed? And he says, well, because it's really drafty in here. Probably have a hairstyle like my own, and so every draft and air conditioner vent, and I need it closed. And so even halfway doesn't satisfy them. It makes neither happy. So she pauses and thinks, and she goes to an adjacent room and opens the window in that room. Brings fresh air into the room that they were in, but doesn't create a draft. And the authors illustrate this is sometimes you can't solve a problem unless you understand the interest of the parties. And they reinforce the notion that you really have to understand what's driving the other party's motivations in order to solve the issue in a way that furthers your own. The sad thing about contracts, really of any kind, but also managed care contracts, because they don't come with footnotes. You don't know half the time why the MCO has included a provision. You'll read it over and you might know what it means, but do you know why the MCO put it there? What interests they're trying to protect? You usually don't. The way you find out is by asking questions to the rep. What does this mean? What's the purpose of this provision? And then you can design some kind of response around it that addresses their concern or interest and addresses your own at the same time. But if you don't even understand why the provision is there, it's very hard to come up with a sort of win-win scenario where you are fixing it in a way that they are going to find acceptable. So the way I do this routinely in any contract negotiation, it's all about the questions. All about asking the plan about why they are doing certain things. And let me give you an example. So my favorite question, of course, is do you have any flexibility with it? The number one question, and I use it in all contexts, both payment and non-payment issues. Plan proposes a payment fee schedule that the client wants, and the client doesn't like the fee schedules, and I say, do you have any flexibility with the fee schedule? And the surprising thing about that question is formulating that way is it's very disarming. It's not bullying, it's not aggressive, it's just a question. And a surprising number of times, provider reps will say yes, and then they'll try to backtrack a little bit. And then that's an opening, a conversation to have about their fee schedule and why it's not sufficient or not market related. So asking a question is a fantastic way to have a dialogue that is usually more comfortable. Also learn amazing things by asking that question. You know, you can also use it to your advantage. If there's a clause in there that's protecting them and not protecting you, you can say things like, why can't this clause protect both of us? And if the rep says it, well, it can. And, all right, well, I propose to change it so that it indemnifies both of us or protects both of us in that scenario. It's a nicer way to negotiate, and you usually can't say no. I mean, why can't this clause apply to both of us? It's hard for them to say no. We're trying to be unfair. I'm not going to hear that back. That is not something likely. So how you ask the question is important, and then it allows you to address their concerns. And you might not be able to do it immediately. You might have one call with the MCO where you go through different provisions to try to figure out why the heck they've included such one-way, egregious, terrible provisions in their contract, and you would never let on about that. And another call after you figured out how to propose some language that could address their concerns while simultaneously addressing your own. And you'll be surprised how better the response is on the MCO side if you know what their interest is in reframing your change to the clause. And I'm going to talk about some examples as we walk through some of the terms about how you might modify their proposal, not get rid of it completely, but modify it in a way that protects you without harming them in the process. Because usually striking a term is usually not acceptable from their end because they had some interest that motivated them. But modifying it might take the wind out of that provision while keeping it still there nominally. So it's helpful to respond to their concerns and generate a variety of possibilities that work, and then find areas of overlap. But you should be focused, of course, on the key red issues initially. You can always come back to the other issues later. You know, people forget that. You know, once you get through the red issues, there's nothing that stops you from going back to them and say, we dealt with all the hard issues. Now let's move on to these. And now they've already invested time in negotiating with you. So there's usually more interest in finalizing it because they've made that time investment. They're kind of hooked. They'll see it through to the end and hopefully resolve those to your favor as well. So here's some negotiation tips that I found across on the letter. First of all, don't assume the MCO contract rep knows anything. I'm serious. Don't assume they know anything. They may not even be in this state. Some of them work from out of state if they're part of a national plan. They don't know you. They don't know what your scope of services are. They may know very little about operations. They may be very far down on the totem pole and have a plan, and what they say may matter very little. You know, it's a big plan, for example, with United. You know, United is a large bureaucracy. You know, they're not just, you know, they're in many, many states, and there's certain decisions that have to go back to legal and headquarters in Minnesota, and certain that decisions can be made in-state by folks. And the provider reps are pretty far down. Meaning what? Meaning you may have a fantastic phone call with United, think you got agreed upon, and then when you get the contract after them, it doesn't reflect anything at all from what you talked about and what you thought they had agreed. My number one rule with United is don't believe it until you see it in writing. Because when you see it in writing, that's usually the point where they've had it vetted by whoever has to approve the final language. And they usually don't offer you language that has not been vetted. So with United, that's just the personality of their organization, has to be in writing. With other more homegrown plans or smaller plans, what the rep says can really count a lot, and they can make changes happen because of that. But they don't understand the business. There's a lot of turnover on their side. Some of them are work under difficult circumstances and situations, and you have to do a lot of educating. It's sort of like any of you that have ever lobbied members of Congress. A lot of it is educating them who don't know staff or the member who may not be familiar with your needs and your concerns. So it's an education job, number one. Number two, as part of that education, learn as much as you can from the plan. Somebody mentioned earlier that the plans sometimes speak almost another language, another language entirely. Yeah, so you have an opportunity here to understand what their language is and learn it. Doesn't happen immediately, but it's a great opportunity to learn from them and to understand why they've included certain provisions in their contract and are wed to those provisions to figure out alternatives. Insist on some standards that are objective. I like to try to remove a lot of discretion from the plans and focus on objective things or external standards that they can't muck around with. So, if the more you can link, payment to an external benchmark that moves and changes upward, hopefully, with payment increases, that's usually better than a plan's proprietary fee schedule. If you contract with a plan to get paid 100% of Aetna's proprietary fee schedule, that means they can change it or not whenever they want. If you contract with Aetna at 100% of the Medicare fee schedule, well, then when the Medicare fee schedule goes up, your rates go up as well. So an external benchmark is often helpful because your plan contracts will automatically renew, and there's usually not a payment increase that's built in unless it's hinged upon an external benchmark for payment. And objective standards mean, what's prevalent in the marketplace as well. So if you get a contract that seems so out of bounds with what they do compared to their competitors, you can always say that's just not consistent with, generally our markets here. That might be fine in Florida where you live, but that's not consistent with how we do business here, in Washington State. You can make that argument. Fairness, that also is an objective standard in some sense. At least I try to marshal it as such and say, this is not fair to us because, and then you explain, helping them, and it's harming you in the process. But likely your plans won't understand why the provision harms you. You'll have to explain that to the provider rep, who might have to repeat that over and over again as they get approval, because it's usually a game of communication and telephone, and some language can get lost along the way. The other thing is, if the plan really is annoying, you can always state the importance of maintaining the relationship over time. Sounds a little bit Pollyannish, but nobody has lost ever any money by repeating that at the start of phone calls or on the call when dialogue gets difficult. Say, this is an important contract to us. It's going to account for a good share of our revenue. We really do care about our patients. We know you care about your enrollees. We want to do something that serves both of our interests and do it right. And quite honestly, you do have a lot more in alignment with the plan than some of the other providers out there. I mean, imagine how much more difficult it is for hospitals who are negotiating contracts with plans. Hospitals and health plans usually are not aligned financially. The more the hospital services that are rendered, the higher the health plan's costs. But if you provide primary care, behavioral health services, things that tend to keep patients out of the hospital, that's much more in line with the plans and a relationship that's ongoing. After you get through negotiating the red critical issues, you'll have to make a decision about whether to contract with the MCO at all, whether to build into the contract some out clauses if you're a little bit nervous or anxious about contracts with that MCO or under a particular payment arrangement, whether you want to contract using an agent or an IPA for negotiations with the MCO if you think you could get a better contract through that process. And I'll talk about the antitrust issues later. But you basically have a business decision at the end of the day. Most of you, will contract with the plan and not just say no, but you may want to build in some protections for you if it's not a very favorable contract. All right. So have a plan when you negotiate with the plans. Don't underestimate preparation in the process. Do know your leverage points in advance. You know, one of the best arguments you can make is this provision doesn't comply with the model contract, or it's not consistent with the model contract language. You know, that's a nice, easy legal argument for why a provision ought to change, or it's not provision consistent with state law. When you have other leverage, like market power leverage and timing, use that leverage. Don't miss out on the opportunity to have a good contract, even a fair, protective contract, as a result of that leverage. Do figure out how to leverage your ACH activities to be able to compete on value and have value-based contracts that help supply additional money and revenue to your organization. Step 2, evaluate critically the contracts. Use a team-based process to evaluate contract provisions and focus on the highest priority issues. And number 3, negotiate firmly, but kill them with kindness, so that you're hard on the issues and not on the people. All right. Let's move into key terms. First issue, scope of services. The scope of services in the contract is much like a scope of work that you might have with any vendor or consultant. It basically is requiring you to do a certain amount of work, certain services. So here, you do want to make sure that the scope is defined in a way that pays you for everything you do. You don't want to be in a situation where it's only a subset of services, so it's too little, and you don't want to be in a situation where it's too broad. Well, why would you care about something that's too broad in defining the scope of services? Because if you're paid a fixed amount, capitated payment for services, and you think that payment amount goes to fund this, and they think it goes to fund this, you have a mismatch. You may not be getting enough in your rate from them to pay for that broader scope of services. So you always want to ensure the scope is defined adequately and reflects and relates clearly to the payment that you're receiving from the plan. In the fee-for-service world, some health plans actually define the scope based on the payment exhibit. What CPT codes or codes they have in the payment exhibit defines the scope. That's one way to do it. In that case, it's really easy. You go to the contract, you look to see what fees you have in the contract, and that tells you what's the scope of your contract. I actually did mention this earlier. When I review a contract, do I just start at the beginning and then work through to the end? No. I read my contracts like reading the newspaper before I went online. I start with the sections I want. And I don't start with section 1 definitions. I jump right to the end, to the exhibits, because that's where all the good stuff is. Because to make sense of the contract terms, I need to know a few things up front. What's the scope of the contract? What are the services that this provider is promising to provide to the payer? How is that payer proposing to pay the provider? Fee for service, capitation, something else, value-based? What lines of business? Medicaid, Medicare, commercial, exchange? Those can all have their own reimbursement rates and formulas as well. Once I know that stuff, what lines of business, payment methodology, I can make far more sense in the whole contract. But I don't start in definitions. I've never found it very meaningful to look at definitions in the abstract. And these contracts have been lawyered over many times, meaning that any capitalized term in the contract is a defined term. So I skip over definitions, which is usually Article 1, start with Article 2, and then whenever I see a capitalized term, I know it's a defined term, and that's when I flip back to the definition section. So I can read the definition in context of the provision in which it's used. And these contracts, you'll find, all of you sort of have the same kind of order. They're going to have definitions, they're going to have your obligations, they're going to have some section on their obligations, they're going to have a provision about payment amount, which will heavily reference the back end of the contract, the exhibit. They'll have a process probably about claim submissions and whether they can recoup payments. There's going to be a provision about confidentiality issues. There's going to be a provision about term and termination rights, and all sorts of provisions related to indemnification. It's like the same guy wrote the whole thing. But each plan does have their sort of unique quirks about what language they have in the contract itself. But that's sort of the order that I approach the contract. So here, scope of services, very important provision. You want to make sure that it covers all you do, nothing more. I read a provision that said recently that the provider would provide all covered Medicare services. I said, really? Are you an ambulance? Are you a hospital and I didn't know it? No, that couldn't be right. So the scope of service is just what you do or what you're licensed to do within your state. Shouldn't be anything more than that unless this is some weird at-risk contract where you're being paid for services. Not weird, I shouldn't say, but an at-risk contract where you're being paid for services and then you're contracting with other providers who you won't pay for the contract. But scope of services usually is just what you do within your four walls. In contrast, covered services are the member's benefits. What are the services that are covered under the individual member's benefit package? So in order to get paid for any service, it has to fall within the scope of services of the contract and be a covered service. One of the issues that behavioral health providers have had for many years is that while the Medicaid benefit is very rich and broad and covers a lot of health and addiction services, commercial payers do not have such a broad benefit package. So there was sort of a mismatch. They might have a contract with a payer, but that payer could have a commercial line of business where they didn't get reimbursed because it was for a non-covered service for that commercial payer. Some of the mental health parity laws have helped change that a little bit. Some state laws have helped change that. But there's basically two provisions in order for a service to be paid, and that it has to be within your scope and be a covered service. Sometimes there are limitations in the contract on how many services you can do that are covered under patient's benefit plan, and plans have limitations for whether you're paid. So if they have a certain number of counseling services or sessions they can have, once they hit that point, that exhausts their benefits, you're not going to get paid anything more. There should be requirements to pay for non-covered services. What happens if a patient comes in, you determine they need a service, but it's not covered by the health plan? Can you still bill the patient? I hope so. Can you still charge the patient some reasonable amount? I hope so. Now, there's some usually restrictions on what you have to do in order to do that, but you should be able to, and they shouldn't be onerous. So if you find that you have a population of patients and there's a service that's generally not covered, what do you have to do? Do you have to get the person's consent in writing in advance? Yes, it sounds reasonable, but are you always in a position to get the patient's consent prior to rendering the payment? Or do you only know it's not covered after you submit the payment and it gets denied? Because if that's the case, getting it in writing beforehand, it will never happen for you. You have to choose, I think, revise the provision so that you don't have to, so that the language about telling the patient in advance is not. Now that doesn't seem very fair to me though, to the patient. So you have to figure out something that's operational that allows you to get paid for non-covered services. Sometimes it has to do with how the patient consents. Do you have to give the patient consent in writing? They have to sign something? Or can the practitioner just make a notification in their medical record? Something along the patient assented to the fact that they will be financially responsible for the service. All depends on how you want to set up the process. But if it's too stringent, you will never get paid for non-covered services. What about how you provide services? I had an organization, and they had a nurse practitioner who was rendering counseling services. And they told me that in their state, this person was licensed to render that service. So they used that person. Unfortunately, they didn't know that person, from the health plan's perspective, was not qualified to do it. They were actually overqualified. So the plan routinely denied all the claims when the nurse practitioner was rendering counseling services. The client would have liked to know that in advance. Sometimes, if you have any kind of sort of quirky situations, unique situations where somebody is doing something that maybe they don't always do in other organizations, you may want to see if there's a restriction, because plans can basically go beyond licensing requirements and impose some restrictions for what types of clinicians can do certain activities that they'll pay for. Also, whether to arrange services by subcontract. What's a subcontract? It means that if you have a contract with a psychiatrist who comes in 3 days a week and you want to bill for their services, that's a subcontract. Most plans prohibit billing of services rendered by subcontracts. Now, why would they do that? Because they typically don't want one provider contracting with another provider who has good rates to get the benefit of those rates. They want each provider to be independently contracted with the MCO. But there are certain cases where that's not going to happen. That part-time psychiatrist, when she comes to your office, she's just going to be she's basically going to function as your employee. Of course you should bill for that. So if you have that kind of arrangement where you have any individually contracted practitioners or groups that for whatever reason you're buying services from and you want to bill, make sure there's not a prohibition that blocks you from billing for those services. You'll have to negotiate it. Now the good news is that I've never had a plan reject the change to make that happen. So in some cases, they won't want to take the provision out entirely because they have reasons for including it, but they will make an exception for individually contracted practitioners, or sometimes I have clients who contract with groups of providers, and so we'll write in an explicit name of a group. So except for such and such group, the provider is not going to bill for any contracted relationships. Whatever your circumstances are, you'll want it reflected in the contract.
Really hard. Doesn't like when I click off it. I'm sorry.
Timely claiming. This is language here that requires you to submit claims to the payers within a certain period of time. In most cases, traditionally in the industry, providers have 90 days to submit claims to the payer to get paid. And then what happens? If you fail to submit the claim on time, you don't get paid. The plan denies it. Now, I'm of the view that life happens sometimes and things don't always go right. You might have a clearinghouse or a new EHR that's implemented, and somehow claims could be held up. They don't go out or they don't go out on time. I always like to negotiate a provision that does not make the plan's denial mandatory. In other words, a language that doesn't say, if you don't submit the claims within 90 days, plans shall not pay you. I like to make it permissive. Plans may not pay you if you don't submit them on time, but it's not mandatory. Why? Because I like to leave the door open. In the event you have like a real world scenario where you don't get your claims out on time, there's sometimes no mistake of your own. The way I tell plans is, by changing this language, it's not saying that you have to pay all late claims. Instead, we're punting. We're leaving to another day to give you the opportunity plan to change your mind later on and decide to pay some late claims if we can make a good faith basis request for doing so. We just don't want to be shut out of that opportunity at the outset. We just want to leave it open that you can pay late claims. Now you have some very interesting protective language here from the model contract. Washington State, the model contract says the contractor, so whenever you see the contractor, that refers to the MCO. The MCO shall allow providers 365 days to submit claims. That's great language, isn't it? You have a year to submit claims to the MCO in Washington State. It's unheard of. Most just have 90 days in other states, and here you've got a year. It's great language if I don't read to the end of the sentence, of course. Submit claims for services provided under this contract, unless the provider has agreed or agrees to a shorter filing time frame in their contracts with the MCO. Yeah, I'm not crazy about that part of the contract language, because it gives you basically the plan, the opportunity to negotiate a shorter time frame. Now, fortunately, I don't know any MCO in Washington State that has read the whole sentence. All of them, from what I understand, gave everybody a year to submit claims, which is great. But they didn't have to. That was a nice gift from them. The Medicaid side, really? Oh, well, there's one exception. Those plans that I've worked with had 365 days or a year. Now, they didn't always do it in the base agreement, but the amendments or the regulatory appendices I saw back there would sometimes modify a short time frame for submitting Medicaid claims. For Medicare and commercial, could be a much shorter time frame. Usually it's more like 90 days, because that's what's traditional and typical. What about billing? So there's actually a requirement that they waive the timeliness rule as a result of certain program integrity, the fraud types of prevention activities by HCA. So if they see that, they figure out, for example, that HCA has paid a claim fee for service where the MCO should have paid it, then the time requirement actually happens not when you submitted a claim, but within 120 days that HCA notifies somebody of improper payment. So you have a shorter time frame to submit the claim after they notify the MCO that you have 120 days to submit basically a correct claim. goes to the MCO and not the state. The state doesn't want to pay fee-for-service claims for services that were covered by managed care. I think this was important during the transition point, but now that all the regions are integrated, it shouldn't happen as much. There may be some services that are still paid by fee-for-service, but probably the HCA is probably limited the number of services that would be paid fee-for-service. What about clean claims? What about the provisions, the language that helps you get paid on time? So there is this weird notion of claims being clean or unclean. Clean claims is the definition for when the clock starts running the MCO to pay you in full on any claims that you submit. And so from a provider perspective, typically you always want a shorter definition of a clean claim, because usually that means that the clock will start running sooner on the MCO. A longer definition generally of clean claim requires you to comply with every technical requirement. Dot every I, cross every T requirement on the claim form. And if you fail to do that, it's not considered a clean claim, and the clock does not start running on the MCO to pay that claim. So generally, you would prefer a shorter definition of clean claim. I'll explain in a moment how the state defines it. Ideally, you would want interest on late claims. So if the MCO doesn't pay you on time, they should pay you interest. And then lastly, you would want typically a clear explanation for any denied claims. One of the major frustrations I hear from providers billing staffs is that they don't even get enough information back to work the claim. They don't know why the claim was denied. They don't know what the flaw was, and they have to basically start from ground zero, or they just guess, then they resubmit, and then it's often rejected again. So, the model language covers some of these requirements. First, it says that the MCO has to meet the timely payment standards specified in the Washington Administrative Code. Hold that thought for a moment, because I'm sure you're not familiar exactly with all the provisions in the Washington Administrative Code. And then it has certain payment requirements in the model contract. Plans have to pay or deny 95% of clean claims within 30 days, 95% of all claims within 60 days, and 99% of clean claims within 90 days of receipt. And I'm pretty much a fan of how the state defines clean claim. Clean claim is a claim that can be processed without obtaining additional information from the provider of services, right? That's a good definition, because that means the clock starts running basically if the MCO has all the information it really needs in order to adjudicate the claim. Yeah, you might have left information off of a field. Who cares? If that field wasn't essential for them processing the claim, the clock already started running. They had enough information. So that's a favorable clean claim definition from a provider perspective. The date of receipt. When do they have received the claim from you? It's the date that they receive the claim from the provider. That's the date that they have that starts the clock if it's a clean claim. What about the date that they pay the claim? The date of payment is the date of the check or other form of payment. Not so great. Why? Because I'm a plan, I write a check, I put it in my desk drawer, and then I don't take it out for 3 months. Have I complied? Yeah, because the date on the check was what I'm being evaluated against, not when I actually paid the claim. So not terrific from your perspective. That one kind of slipped by, I guess, HCA, but generally it's a good provision. Now, what do I really like about Washington state law? This is why I like Washington. One of the reasons why I like Washington state law. That reference before on the prior slide that I did in bold, that one, that's this. That is the requirement under state law that applies to all managed care contracts, not just Medicaid lines of business, but Medicare and commercial as well. You can see that there's a prompt pay provision under state law that applies to you, which is the same thing that was reflected in the model contract. And more importantly, they have to pay you interest. If they don't pay you on time, they have to pay you 1% interest and 4% a year. And they have to pay you this without you actually having to submit an invoice. This will be automatic. So this is one of the most favorable interest payment provisions of prompt payments in the country, and it's right here in Washington state. Also, if they deny a claim, they have to communicate to you the specific reason why the claim was denied. It's right there in black and white. And if they make a denial based on medical necessity, then they have to disclose the supporting basis for that decision. So very favorable language under state law that applies to all the MCO lines of business, Medicare, Medicaid, and commercial. What do you do with that? Ideally, you have that language inserted exactly as that in the contract. Now, why would I recommend that? Because in the future, if you have a dispute with the plan and you have a provision in your contract that just basically says the plan agrees to comply with the terms of state law, to work with if you're dealing with a dispute in your claims appeal process. You can't point to a provision in the contract that entitles you to about 1% interest or that clear communication about what's been denied. Put yourselves in the position of having to resolve a dispute on your own without a lawyer. You would want to point to a contract term specifically and say, this is what we're entitled to in black and white, not have to point to a provision in state law, even if the state law applies. So my first choice in all the prompt payment provisions in the contract is to cut and paste the state requirements and put them in. That's my first attempt. That's my first choice. Sometimes they don't let me do that exactly, and I have to cite the regulatory provision that's second best. But I'd like to have clear language in there what the requirement is, because it allows entities to be able to basically protest and get their rights clearly written in the contract to deal with them when they've been violated. So the question is there a similar prompt payment requirement that will apply to paper performance arrangements? And the answer is no. You would have to write it and put it in. So if a plan didn't pay your performance incentive timely, whatever the repercussions would be, and maybe you can tackle onto this, that if they don't pay you your incentives, on time, they have to pay you 1% interest consistently. This is great language in Washington State. Don't forget about it. That's the other thing. If you don't have it in the contract, sometimes information gets lost. You may come and go. You might leave your organization and new people come in. They may have no idea of this protection. But if you have this protection in your contract, and then they can pull the contract and see it, that gives them something to go on and know that they can use this to their benefit. I should mention something else from a practical perspective. That 1% interest isn't going to make anybody rich. That 1% interest is your leverage to negotiate settlements. Think about it that way. So I had a client that had a payment dispute with a plan, and they were owed, I think, about $250,000. No, this was actually, they were owed $500,000. We argued that if we had the penalty, if the state imposed the penalties of 1%, there would be this huge amount of interest that they owed. We offered to settle for just the underlying value of the claim. That's all my client wanted to get paid. They didn't really care about the interest. And the plan basically said yes. So we were able to give something up later to get us paid on the underlying claim. That's a good position to be in. That's a good outcome. So 1%, that's your leverage, but that's not necessarily money you'll make. Correction of overpayments and underpayments. So all the plans have contract provisions that allow them to recoup overpayments to you, meaning money that they overpaid you. You will have very few underpayments, but you can work on it. Let's first talk about overpayments. This provision is usually really unfavorable to the plan, to providers, because plans can recoup these overpayments without having to provide you any notice whatsoever, and they can do it by offset, meaning they just deduct the amounts that they believe is an overpayment from amounts due to you. Now, it drives when I hear CFO is nuts, because it basically masks that they're taking money back. Unless you have a very detailed oriented staff that is looking at every single EOB or remittance that you get, you won't know that the plan is taking back money from you, because it's hidden by the offset. It also kind of screws up your financial book, because if you don't know the plan is taking back money on a certain claim, then you may think that you should get paid on something, or you did get paid on something, and you really didn't, because the plan took the money back. Now, many of you would like to remove the offset provision entirely. And you can ask for it if you want, but you won't win. Plans love the offset tool, because they know that their final remedy can always be take the money back by offset. So when I negotiate with the plans on the overpayment provisions, I try to negotiate for 2 or 3 things. One is notice of the overpayment, to give you an opportunity to object. And maybe you look at the claim and say, that wasn't an overpayment. That was a valid claim. We got paid on it. We should keep that money. The standard provision by the plans doesn't have any rights or a way to object. So the first thing is notice. The second thing is the right of appeal. What does that mean? Well, plans have administrative, appeal processes that they use when they deny claims. They can use the same process to review claims of overpayment that they want to get back to give you the right to object or show. And then 3, I try to negotiate a provision that allows you to cut a check and send the money back if it is determined to be an overpayment. It doesn't muck up your books. The CFO would want to cut a check instead of an offset to allow the provider to do it. So that the final remedy is by offset, but it doesn't happen automatically without notice and without the opportunity to send money back by check. That's on the overpayment side. What about turning the provision around so it protects you? Let's say you do an audit and you discover that you were paid by the health plan, but not enough. So these are adjudicated claims, and you did an audit, a year and a half later, and you determined, oh my goodness, they paid me $1 on these claims, we were entitled to $300. Look at the window for appeal, that window is unpassed for 60 days or whatever you have. You can basically do better by having an underpayment provision, right, in the contract that allows you to recoup underpayments that you. Basically, what you'd be asking the plan to do is, make the provision even-handed. It allows them to recoup overpayments, and you can recoup underpayments. Now, some plans have issues about you recouping payments back from them or underpayments back for some undefined period of time that goes back, many centuries. You say, well, we can agree to limits. How about 2 years? Actually, they say yes. And say, that's great. That sounds reasonable. We won't try to recoup that for 2 years from a date of service or date of payment. And then you say, and the same should apply to you. You shouldn't recoup any overpayments after 2 years of the date of payment. And it's hard to sort of wiggle out of that at that point, because now you have a term that applies equally to both parties. So the nice thing to do is to make sure there is some limitation on how far back they can go, because your CFO will be driven crazy if they start recouping overpayments from things that are probably more than 2 years ago. Because those books have been long. What's the possibility for getting these changes? Very possible. Even United Healthcare, which I'm not a huge fan of, has changed their contract when it's negotiated to permit providers to recoup underpayments, send checks back, be notified, all those sorts of things. You just have to negotiate. Whether you will win on any of the provisions that I'm recommending changes on, it all goes back to whether you have leverage. So the answer to whether you can get the change has to do with leverage. How much does the plan need you? Are they obligated to contract? But these are the types of changes that I would strongly recommend if you have leverage and you can play that leverage to get change so it's a more balanced contract. The one thing that has happened historically for providers is that there will be a change or a retroactive disenrollment by the state. So let's say the state makes a determination that a beneficiary is no longer eligible for Medicaid, right? They do that all the time, right? They check benefits, this person wasn't eligible. And they say to a plan, this person wasn't eligible as of 6 months ago. Retroactive disenrollment for Medicaid. So what does the state do? They take back the premium dollars that they paid that plan for that individual because they weren't eligible for Medicaid. And then the plan comes to you and they say, hey, that person wasn't eligible. We're taking back all the money we gave you. So they take back money from you that they paid you for that period of non-eligibility. And then you go to the patient and take the services back. Sucking that you're still listening. Yes, you can't do that. Once it's done, it's done. You provided the service. So who ends up holding the bag for the state's changes in eligibility? Typically the provider. Because you are the one that at the end of the day bears the loss. Are there some exceptions? Yes, sometimes you can bill another payer if you meet the timely filing requirements. You might, if the patient has other insurance that they're eligible for, you might be able to bill them, but you might not. So, and that would take a lot of work. Many times when I've tried to negotiate changes to these provisions, plans have said, no, we can't allow you to keep any payments that we've made to you in these circumstances. We have to take the money back from you. Look at Washington State says in bold. The MCO may recoup payments made to providers for services provided to enrollees during the period for which the HCA recoups premiums from those enrollees. Now, I'll give you a mini law degree. When the government or a contract says may, it means exactly what it suggests. It's permissive, it's not mandatory. When the government uses the word shall, it's mandatory. So HCA shall recoup premium payments from individuals who are retroactively enrolled, retroactively terminated, whose coverage is terminated. They have to take the money back from the plans, but plans don't have to take the money back from you. It opens the door to make an argument to the plan that you basically lived up to your end of the bargain, right? Under the contract, it's a simple promise. You promise to provide services to their enrollees, and you check on the date of service that they enrolled in their plan, and they promise to pay you. Why should you be at risk for the state's changes in eligibility? Why shouldn't that insurance risk be on the insurance company or on the state? But falling on the provider's doorstep is never. So I like this language here because it basically makes it clear that the plan can let you keep those dollars that they pay you for services during that period of retroactive disenrollment. And if they want to let you do that, because you usually don't have any mechanism to recoup that money from another payer or from the patient, him or herself. What else? There is one blanket exception where plans can't actually take money back from a provider. It's kind of varied, but it's in the law. And that is if a plan is given a written utilization review decision, where they've given you approval for a particular service. Doesn't matter whether it's emergency or non-emergency care. If they've authorized it under a prior authorization plan, sometimes it's a written decision, but follow the written policies for that decision, they can't take the money back retrospectively, even if they have a retrospective disenrollment. So although we rail against getting approval by utilization review from the plans, it's the one case where they can't actually take the money back later and change their mind for any reason. Once they give you approval, you got it. They can't take the money back later. What about exceptions? Disputes. So as I mentioned earlier, since somebody had asked, I often propose like some sort of streamlined, expedited process for claims, and most plans have some appeal process for you to follow. It's all governed by fortunately, their provider. So what do you do after that? I recommend that there be different layers of ways that you appeal things. First, starting with informal negotiation. Some of the plans do a really nice job in these provisions. They say both parties shall meet in good faith, within 60 days to resolve the dispute. Nice, clear language that the parties would come together and deal with it. You may have to notify formally by sending notice to the other party, but you have to come together and try to informally resolve the dispute. Nice and clear and simple. Sometimes you can't do that, though, because there is this strange language that's written into the contract that blocks you from doing so. So see that third box down on the left-hand side, where it says sometimes the contracts require you to have completed all of the plan's administrative appeals process, which in theory makes a lot of sense. In practice, it can trap you. Let's say there's 5 levels of the appeal process. Sounds really rigorous. And then at the 5th level, they don't give you a final decision. You're stuck. You are stuck right there because you have now not completed their administrative appeals process, and you're foreclosed from going to pursue any of the other remedies under the disputes clause. So be very careful about language that requires you to complete their appeal process. If you are certain, if you look at their appeals process and you assure yourself you can't be stuck at the top level, that there is some obligation that they have to render a final decision, within 30 days, and if they don't, you automatically win, that's great, then you're fine. But if there's a possibility that you can be stuck there, then they may play that game with you, because I've seen it happen, where they just keep you on this level of administrative appeals, and it blocks you from pursuing these other avenues. So don't get stuck. So that's informal negotiation. Mediation, that's when you have a Secretary of State kind of approach, some third party that goes back and forth to try to resolve the matter between the two parties. I don't have anything against it. That's fine. That's reasonable. Typically, the parties have to split the cost. It's not a huge cost sometimes compared to what's owed, so it's a worthwhile investment. But it's usually considered non-binding in the sense that you can try it, you can see if it works, the mediator might have an idea, but if it's not embraced by both parties, it doesn't stick. That's how it works. Now, arbitration is a whole other matter. Arbitration is a substitute for going to court. It's typically viewed as one possible option for litigation, and it allows the parties to resolve their dispute by going to a private contractor, a private party, an arbitrator, for a decision. Here, you do want it to substitute for going to court. So it should be binding arbitration, meaning you go through it, the party that wins, they win, they can go to court to enforce that arbitrator's decision, but the loser can't go to court and relitigate the whole thing. That's the way it's designed to work. I would say 4 out of the 5 plans in Washington State follow that logic. Arbitration is binding. The one exception I found, I think it's Molina, they have a non-binding arbitration provision in their contracts. And it's always confounded me. And I finally figured out why they want that. See, at first I would think, why would anybody want to go through the hassle and cost of arbitration just to have the loser go to court and relitigate the whole thing? And then I got very cynical and I said, well, that's because Molina knows that most providers don't have the financial resources if they lose to go to court after they go through arbitration. Because arbitration is not cheap. I mean, there's still significant costs. There's a legal process involved. There's often discovery. Sometimes there can be depositions. You have to pay for the arbiter wherever they are to fly in. You have to host them. It can go on for a couple of weeks. There's significant legal costs involved. It's not a cost-free option. And so maybe Molina's thinking they go through that effort for arbitration. Even if they lose, then they're not. Even if we lose the plan, we have the money. We can go to court and relitigate the whole thing. So that's my cynical view. But if you have a contract with Molina, check it. See what it says. And I encourage you to try to change it so that it's not binding as arbitration. Arbitration is binding. Because the only party that it really favors, I think, is Molina, not you, when they have non-binding arbitration. Some of you may decide you don't like arbitration at all, which is fine too. That's a valid decision. You may want to be able to go to court and not have your parties and your dispute settled by arbitration, because sometimes some folks feel that at least if they go to court and they lose, at least they can appeal to the Court of Appeals or higher if they have a significant dispute. But it's usually an organizational decision about what that is like. All product clauses. Have you heard of these? These are what require you to participate in all the plan's lines of business. So MCOs refer to their lines of business as products. You could have a Medicaid product, a Medicare product, a commercial product, and an exchange product, for example. And all products clause would require you to participate across the board, all of their current lines of business, foreclosing you from opting out. So if you may wanted to just work, be in their Medicaid product, but this forces you to participate in their commercial and Medicare product. All product clauses are damaging to providers because it often forecloses the opportunity to opt out of certain products. In addition, all product clauses require you to participate not only in all products in existence at the time you sign the contract, but any future product the plan wants to offer. So next year, they want to offer an exchange product that pays you $1. You've already agreed to participate in it, because you signed an all products clause as part of your contract. So if you can't tell from my tone, I'm not a big fan of all product clauses. Now, will the plans typically agree to remove them entirely? No, that's a really hard position for you to take. If you take the position with the plan, just strike the clause, you will have an uphill battle. Plans will likely say no. My approach is much more incremental. Have to acknowledge what their interest is. What's the plan's interest to have an all products clause? You have to know that at the starting point. Their interest is valid. It makes it very cumbersome from a plan's perspective to have separate provider networks for each of the products they offer. Having one single provider network that you can use and draw upon from across the board for all their products, much simpler administratively. So you have to start at that point and recognize it. So plans are loath to remove all product clauses when they have them in the agreement. So what do? You chip away at them. You provide an exception that you can opt out. If you're notified in advance of the new product, you can opt out of any future product. Now that doesn't take away the fact that you have to participate in all their lines of business today. You have to do that, resolve that issue separately. So if you knew you didn't want to do the commercial product and the Medicare product today, you'd have to resolve that through separate negotiations, separate provisions in the contract. But dealing with the possibility of them offering new products in the future, you can tinker with it and just give yourself an opt-out. Does it completely undermine their clause? 100%. But that's what you wanted to do, right? You wanted to be able to opt out. You're not saying you won't ever participate in their product. You just want the right to be able to negotiate and review the payment terms in that new product. And that's what an opt-out right would be. When I did a similar training in Nebraska, when they were integrating behavioral health and managed care, A whole slew of providers raised their hands and said, we never got contract amendments from United when they wanted to add us to their Medicaid product. Why? They just added it to our contract. How did that happen? And I said to them, do you have an existing commercial contract with United? They said, yeah. Do you have an amendments clause and an all products clause? They said, we don't know. I looked at it. It had an all products clause and an amendment clause that allowed United at any time to add a new product to their contract. So suddenly they were part of the Medicaid product and they had no ability to negotiate terms for their participation. So these are very strong tools that plans use to move providers into their network to meet network adequacy requirements that you should be aware of. There's some language here about from Washington State in the Washington State Administrative Code that affects how the all products clauses would work. So here there's language that says that an MCO can extend the payer's Medicaid rates or some percentage of the Medicaid rates that governs a line of business to a commercial line of business offered by the payer that's not administered by a public purchaser, so a commercial product. And then it says only if the healthcare provider has expressly agreed in writing for the extension. I find this so confusing. I do not know what it's trying to say. I can't figure out if it's trying to say that plans cannot extend Medicaid providers to commercial products at all, or it's saying they can only do so if they pay at least Medicaid rates, or they can only do it if if the healthcare provider has said yes to it. It's very, very murky. And that's what state law, basically the state law says about it. Because I wouldn't rely on it because it is so confusing. I wonder if the plans understand exactly what it's trying to do. I think it's much better just to get clear language about whether you have the right to opt out and whether you have to consent to each new product that's offered by the MCO. What about collecting cost-sharing obligations from patients and whether you can decide not to or to reduce them? There are a number of providers that have policies in their organization where they want to waive cost-sharing obligations. They might have charity care policies. They might be an FQHC that has to have a sliding fee schedule that wants to extend those discounts to patients that have insurance coverage. Or you might be in a high deductible exchange product. Some of these marketplace plans have very high cost-sharing obligations, $7,500 deductible. Well, what low-income person is going to have $7,500 just in their back pocket that they cannot pay that deductible? Nobody. So usually what's happened is many primary care and behavioral health providers basically are at risk for all those dollars because it's the patient's cost-sharing obligation. What's that? If they have the cash, they may not even pay at all. In fact, one of the interesting things is that some of the providers have been induced to participate in these exchange products because they're offered really good, favorable rates. So you might be offered 300% of the Medicaid fee schedule, but that's not coming out of the plan side. That's what the patients would end up being responsible for. So on paper, they can look like really great reimbursement rates. But if you don't know the cost-sharing obligations on the patient's part, you may not realize at the point of contracting that the patient actually bears the financial responsibility. And how good are patients at paying their bills in full? Not so great historically. So one thing I hadn't mentioned yet, but is worth pointing out, is that how do you ever know a patient's cost-sharing obligation in any kind of commercial plan? It's not going to be in the contract. Contracts do not indicate cost-sharing obligations, deductibles, or costs. It simply says that if there is a rate that you and the plan agree, the plan is obligated to pay you the rate less cost-sharing obligations, whatever they might be. So if the patient's cost-sharing obligation is 100% basically, then the plan has no financial obligation to you because it all comes from the patient. So I've been counseling, in particular, primary care providers and behavioral health providers to scrutinize any insurance products that are covered by the insurance exchange. See what the cost-sharing obligations are and make an informed decision about whether you really want to participate in those networks. Because once you participate in the planned insurance exchange networks or any other of the products, you will start getting more patients, right? That's basically the deal you make. I'm in your network, I can expect more volume. Patients can find me on the network list as a participating provider, and I'll get more patients. So by participating in any product, you will increase your volume of services, but if you have these high deductible policies, products that you're part of, you may be having larger financial exposures as a result. I saw an interesting study by one of my clients where they were trying to figure out exactly where they were losing money. Because they had first come to me for help with negotiating reimbursement rates. And I said, before we do that, why don't you look at where you're losing the money? And they did a financial analysis, and they weren't losing money because they have low reimbursement rates. So their reimbursement rates were the same as anybody else. They were losing money from the cost sharing obligations, where patients weren't paying their part, and they had a number of high deductible products that they were participating in. And so I said the focus should not be on reimbursement rates. That will just increase your losses that the patients are responsible for. Your focus really has to be giving some attention to how you're going to improve the collection efforts you're making for patients who have cost sharing obligations. Maybe you have to find mechanisms. I know some people counsel those patients at the organization. Maybe you have to think about sending multiple letters to the patient, finding a payment plan with the patient. You know, sending it off to collections probably doesn't do much for you or for the patients. Now they have, you know, a comment on their credit reporting history. But think about whether you want to participate in these high deductible products that you're losing money on. If you do want to waive or reduce cost sharing obligations, then you may have to tinker with your managed care contract to do so. Most plans require the provider to collect in full all cost sharing obligations. Why? Because it's put in there as a one instrument to reduce utilization. The plans are expecting the patient's skin in the game to reduce utilization. Hence, they require providers to collect the cost sharing obligations. So, if you want a waiver from that process, you want to be able to decide not to for cases of financial need, or because you have a sliding fee schedule that you want to extend to a patient, make sure you get language that allows you to waive the cost sharing obligation for the patient. Otherwise, each time you do waive, you'll be basically breaching your contract. You'll be violating the terms of your contract, which require you to collect. So a CFO once told me that your financial risk is the amount of collecting any cost sharing amounts from the patient. It's true. That's your financial risk. I had to go to one of these outfits, the MedExpress, for when my back went out, and I was just so impressed about their collection efforts. Because when I showed up at MedExpress, one of these urgent care clinics, not only did they collect my copayment, which was probably still $100 or something, or $50, but they actually authorized on my credit card the amount of full payment in the event my insurance company denied payment of the claim. Wow, that's like a hotel when you check in and they authorize your card for the incidental. That's exactly what they were doing. They were covering their losses in the event that the MCO didn't pay. And I was like, I've never seen that before. That's brilliant. That's now, I'm not recommending that you do that for all your patients, but I'm saying, like, some people are thinking about this, about their risk, and they, I guess, can afford to do it as part of their business model, and they're for-profit. They don't think they have any non-profit urgent express units out there, but that was what they decided to do. Because there's only one other provider that collects in full at the point of service that I'm aware of. Can anybody think about that in the healthcare industry? What is one provider type that always collects in full? Not what I'm thinking about. Usually because it's not covered, right? Something that's covered. Not elective, something that's covered all the time, but you cannot get it unless you pay your cost sharing obligation. Bingo. Pharmacy, scripts. Can you take the drug from the pharmacy if you don't pay? Nope. That's called theft, right? Because they adjudicate at the point of time in their little kiosk and their computers. They know exactly, the MCO approves the claim, and they know what your cost sharing obligation is. You have to pay it before you walk away with the drug. I think I made this point. Usually MCO doesn't permit you to waive. If you want to be able to waive, add in language to propose to change it. Now here's another thing where you have to think incrementally. Is the MCO going to allow you usually, to waive the cost sharing obligation anytime you want? Because they want to use it as that utilization tool. So what do? You narrow your request. You say to the MCO, I realize and I understand why you impose cost sharing obligations on patients. However, we have a significant number of patients that are below 200% of the federal poverty level. We want to make sure that they do not have any financial barriers to receiving primary or behavioral health care. Will you let us waive that? All will say yes. Sometimes they come up with fraud arguments. Oh, we can't do that because of the fraud and abuse law. It's just not true. All the fraud and abuse laws always allow any provider the ability to waive or reduce cost sharing obligations or pay for individualized determinations of financial need. it's in federal law. So if you do hear that argument that you can't do it because of the fraud laws, make sure that you counter it and say, no, actually, the OIG, Office of Inspector General, has a nice little paper, special alert to providers that they issued back in 1998 that said any Medicare provider could waive a reduced cost sharing obligation, and it covers Medicaid as well. So there should not be any problem doing it for individuals that have financial needs. One of my favorite provisions that I like to take away, this is one exception to my rule. As you've heard, most of the time, I will just kind of like creep around the edges of these provisions and tinker with them to remove the offending language. This is one I have to take out completely. This is a provision that makes you financially responsible in the event that the MCO if the MCO has a fine imposed upon them by the state or the federal government. So let's say HCA does an audit of the health plans, and they realize that one of the plans does not have a sufficient provider network. And the plan can argue that that resulted in part because you failed to notify the provider, the plan, that you were closing a site or losing some practitioners. This type of provision, I call it regulatory penalties. Unfortunately, it's not highlighted like that in these contracts. These types of provisions allow a plan to recoup penalties that they've been assessed on them from providers. If they can show that the provider did something wrong, didn't comply with the contract or the provider. Do you really want to take the risk for a $3 million penalty? Probably not. Basically, there are unlimited amounts of risk. You can't appeal it with the state because you're not a party to the contract with the state. This is a contract between the MCO and HCA, and the MCO and the Medicaid agency. So for my review, these are one of the provisions, one of the rare provisions that are just not reasonable risks to take. You should not be bearing somebody else's risk for doing something wrong. The MCO was fined because they did something wrong, not because you did something wrong. You say to the MCO, there's a mechanism in this contract if I fail my obligations. It's called indemnification. Point to the provision, every plan's contract. That indemnification provision allows you to recoup from me any payments, claims, or penalties by third parties in the event that I commit any kind of negligence or willful misconduct or breach of this agreement. You've got it right here. That should be enough to push them away. But whether you can do that goes back to the first question. Do you have leverage? Because I've seen United take the provision out. I've seen Coordinated Care take these provisions out. Many plans are willing to take them out if you have leverage and they need you in their network. Because the people that really care about the regulatory penalty provision are not the operational people, the lawyers. The lawyers were smart by including this language in their agreement. They were basically minimizing their financial risk. But it's not a key operational provision. The operational folks just want to form their networks and meet network adequacy. They do not care. They will roll on this provision given the opportunity to do so. So feel free to try to excise it from your agreement on the basis that the plan doesn't need it. They can already recover from it. Is that true? Mostly. It's not untrue, but it's harder for the plans to use indemnification to take money back. Why? Because it's not like offset. This provision typically allows a plan to recover the regulatory penalties by offset from the provider, meaning they can just take it out of the money that they owe you. Indemnification would require the plan actually to sue you in court and then to recoup that money that way if you're not willing to pay. So I'm a fan, take this out, let the plans use indemnification. It's harder for them. Otherwise, you could end up owing money back for the next 10 years. The plan, basically they're not paying you anything because they're recouping their penalty and offsetting your program. Not a situation that you want to be. Shall we take a break now? I think it's time. It's 2:16. Take a 15-minute break so we can recharge a bit, and then we'll resume.
I think we already did, and they're also putting it in. So let me get your email just to make sure we get it to you. We just let me get your email.
This is question of
L-E, oh, I think. Got it. Perfect. I'll make sure to get those.
That's the eligibility. Other issues come up in some of the hard. The donut hole. They start shaking.
You know.
Yeah.
Or if I'm not great, doesn't be hard, but, sorry. Yeah, you don't get it.
I don't want to see any yawns over here. Don't remember, I'm 3 hours ahead of you. I'm going to head out. I already head up at happy hour time. It's 5:15.
You're talking about that cost share. You know, in Montana, they have co-pays. And you can waive that. Get a nice service. What's the point when nobody's going to pay it? They're not going to be denied service for it.
Okay.
You know that issue with
It probably makes a great point for a politician. You know, politicians have their some skin in the game, but it's not doing anything.
But you get paid $4 less for that service.
Right.
Yeah.
That's what it does.
And it adds up. The volume over time.
Correct. When you're submitting 6,000 claims over a month, absolutely.
That's right.
So I don't think people realize that having that in there, even though you don't have to collect it and the client doesn't have to pay the service, feeding that cost.
That's right. You're subsidizing people.
Yes, absolutely.
For that
$4
amount.
per service is what it is in Montana. Not everybody.
Right.
Okay. So anytime you're
Right.
service, take $4. Take $4 on how much you paying to get the claims submitted.
In your head, add another $4 to the amount that they pay you.
Yes. It's interesting that I've negotiated really well.
Okay.
MAT patients that are in counseling, so.
Might give you more leverage at the negotiation.
Very much, because I was able to show that we decreased residential referrals.
Yeah.
So we kept people out of residential, saving more money.
That's exactly my point.
Correct, so that's what I'm.
Yeah.
You found a win for them.
Absolutely.
For providing more of your.
One.
Yeah. Everybody in the room thought the same way. It's take negotiations a whole.
Don't talk about how much.
Exactly. Right.
Yeah, you gotta show what you're gonna cut down the cost.
What's your value?
You're gonna decrease. David, I said hi. Stations for dental purposes by 50%, and they are meeting that goal.
How do they do it?
They got, because Medicaid dental only pays for full and cheap.
Right.
They got some scholars.
Ah.
Yeah.
So that's a huge issue.
Yes, we're here to say, I can actually do some dental work, not be active. And it's cool. It's like what they're doing.
It's very cool.
It is.
Aren't all prison stores in provider one now? Right. So, can any provider assess for a prison score of a patient? No? Really? Yeah, it's a lot of yeah. Yeah. I couldn't hear it. That's it. You're gonna call it that. Writer organization. That's yours. It's not mine. Yeah. Okay. Is that yours? Yep. I don't know who's got mine. I don't have it. I was complaining about the quality of our contract. Just printing out all of these little like but you know, Adam's absolutely right. You kind of figure out, okay, this is the most important thing that we find now. Figure out if you can do that. Right. I know. Pick your coat on, yeah. Oh, me too. I must have been on the same wavelength. Like 4 o'clock. I've got a whole other hour. I know. You know, what happened to leadership? Okay, all right. Really?
Yeah, I know. Yeah, you guys are like Wild West over there. Yeah. So that's why I was pretty concerned about it. Like, tell them that they have to have family leave. I mean, it's just weird the way that people interpret some of that stuff. And everybody has their own perspective. They're all reading material if he's tried it. Horrible.
No, you're good. Clean up. I'm just gonna sit down.
Right.
All right, we are in the final stretches.
You're from the East Coast, and that's after dinner time for you.
Happy hour time.
Yeah.
But I will forego it a couple hours. We are in the final stretches of the training today, so thank you for hanging in there. I understand if you have to leave early for transportation issues to get back from wherever you came from. I'm as eager to finish the training as you, since it's past my happy hour time. Having some good craft beers here from Washington State. I'm done. Great beer scene here. not just a fan of IPAs and beers, but also IPAs and networks. But so we'll finish up the regulatory the provisions in the contract, and then we'll move to networks. So we left off, we're just going to talk about access standards. It's really access and appointment standards if you have a look at these contracts, because it regulates how quickly you have to provide services and appointments to patients. There might be provisions that deal with maximum waiting times for establishing appointments of various categories. So if you have an urgent service, the patient has to get into your organization sooner than if they have a preventative one. That makes sense. But there may also be requirements related to your hours of operation, as well as after-hours coverage and on-call coverage. So I find that almost every contract has a provision with a primary care provider or behavioral health provider that says that you have to furnish services, covered services, on a 24/7 basis. And I say back to the plan. We're not an ER. Do you really think they provide services 24/7? And covered services, because that's how it's phrased. Covered services, all your services that are covered under the plan's benefit package. And they say, oh, no, that's not what we mean. We just mean they can have a telephone answering service after hours. And I said, that's not what it says here. It says that you have to provide all services on a 24/7 basis. Can we write in language that says which may be provided through after-hours call coverage arrangements or a telephone answering machine, so forth? And they say yes. So I always add into that language to make it clear that you don't have to be providing your full range of services 24/7. Some of you might want to add in your after-hours coverage process. Somebody calls after hours. I've even seen language about maximum waiting room time sometimes, that patients can't wait a certain period of time. My general rule of thumb is this. Look over the access and appointment standards requirements and ask yourself this. Am I sure I will meet these requirements 100% of the time? If the answer is yes, you can move on to the next provision. It's not an issue. But if you have some lurking doubts in your mind about whether you always meet those requirements, then think about adding some modifying the language. So rather than having to meet these requirements 100% of the time, you have to make all reasonable efforts, best efforts to comply with these requirements. So that in the event that you have a situation where you don't, you're not automatically breaching your contract with the plan. That can result in a reason for them to fine you or terminate your contract. So what does Washington State require? They certainly break it out for appointment standards. Emergency services have to be available 24/7. I presume that also applies to crisis services because that's how they're paid. They break out for urgent symptomatic office visits, and that applies to primary care, behavioral health care, other types of providers that have to be provided within 24 hours. And they have a definition of an urgent symptomatic. They have non-urgent symptomatic care from either primary care providers or behavioral health providers. So from a capacity perspective, you have to know, do we have the capacity to provide services within 24 hours when the patient calls up for an urgent behavioral health service or an urgent primary care service? Same is true for non-urgent care. Ask yourself whether you have the current capacity to do so. Hopefully the answer is yes, and you will comply with those appointment standards that are set out in the contract, which reflect the rules. What about notification back to the MCOs? MCOs have very long notice provisions where it seems like you lift your thumb and you have to notify the MCO. I like to scale these back a little. Sometimes you have to notify the MCO if one of your practitioners is being investigated by the state board that licenses them. I find that a little bit unfair, because in our experience where we've had practitioners of our organizations who are being investigated by state medical boards and the like, we typically, it's just in the investigation process, we typically don't want to notify anybody about it. We don't want to tell the MCO, we don't want to tell patients, we don't want to do anything until the investigation is complete and the state decides whether they want to take some action. Suspension, take the license, or whatnot. Because in the meantime, we're doing our own investigation, or the client is, to figure out, does the allegations have merit? You know, some patients are complainers. They might lodge a complaint with a medical board that has no merit. And if that's the case, it is what it is. Why should you have to notify the MCO? What are they going to do with it? What can they possibly do in that situation if the state hasn't finished their business investigating? Same is true, let's say a provider, if one does lose their license, So providers should seek to avoid a contract provision that requires you to report a clinician whenever they are in jeopardy of losing their license, because that could be considered slander or defamation if it's unsubstantiated. So I like to change the language that you're only reporting to the MCO in the event that there's some kind of final action, removal, they lose their license, they have their license suspended, there's a criminal conviction or a civil violation of law, then the notice provisions proceed. Now, do the MCOs love these changes? No. So I do it again incrementally. So rather than doing away with them entirely or taking out huge chunks of information, I add some language in advance in the sentence. So I might add something that says, that you'll have to notify the plan in the event that whatever action that occurred impairs your ability to perform your obligations under the agreement. So that essentially I'm setting up something almost like a materiality standard. If whatever the situation is that is bad caused you some problem in fulfilling your duties under the contract, then you have to notify the plan. But if it doesn't impair your ability to perform under the contract, you don't have to notify the plan. And these seem to have gotten in sort of under the radar, releasing notification obligations, which in my view don't really make much difference to the plan. I can't really do it. The other change I made, it has to do with the licensure. Sometimes you can have a provision by the MCO that if they terminate one of your clinicians, they have the right to terminate the entire contract as well. That seems a little bit underhanded to me. I think the termination should only apply to the individual clinician if he or she is using practice medicine or whatever what they're practicing, but it only affects that particular clinician and nobody else, and not the entire contract. You don't want one person to have basically the ability to torpedo your entire contract with the MCO as a result of their misconduct. Credentialing. Usually, many providers complain to me about credentialing processes. They find them duplicative. They have to do it over and over again for the same staff, every single MCO. There's delays built in because until they get the provider credentialed, they can't bill for that practitioner. Some plans delay credentialing activities. They think to starve them from being paid, and a lot of providers complain about it. So what do I recommend? Well, here's one thing not to do. I had one provider who told me one time that what they would do is they just put a different provider on the claim form that was submitted to the MCO. And I said, you did what? Yeah, we took a credentialed practitioner and we put them on the claim form who's actually furnishing the service. And I said, you know what that is, right? I mean, no, I have them co-sign the record. No. You're putting on the claim form a different provider than who actually rendered the service to get around the plan's credentialing obligation. There is a word for that, and it's called fraud. Thank you. It's a material misrepresentation because you know that had you put the actual practitioner who rendered the service, it would be denied. So it affects payment. So that's a material misrepresentation. Don't do that. Don't do that. And co-signing the medical record, that's not a solution. That doesn't fix the problem. So that's not the solution. There are some providers that are very savvy in the way that they delay new practitioners' start dates until that practitioner might be credentialed by at least one MCO. There are some providers that make sure that those new practitioners who are not credentialed yet don't see any insured patients or managed care patients until they're credentialed. So they might confine them, if you will, to seeing uninsured patients or people who are covered under fee-for-service, traditional Medicare, and fee-for-service Medicare. Have it, but not managed care. That's one way to approach the situation. Others have looked to delegated credentialing methods, where a plan can actually delegate a provider to do the credentialing activities the plan has to do. So the plans don't do credentialing because they do it for kicks. They don't get any more money for doing credentialing as a result of it. It's an insurance or contractual obligation. So Medicaid managed care regulations, so Medicare managed care, Medicaid and Medicare managed care regulations, state insurance law. That is what requires the plans to credential any contracted participating provider. So they're not doing it for fun. Do they do it in ways that can deny you payment? Absolutely. But they're not doing it for fun, and they have the ability to delegate that administrative task to a provider. So some providers become the delegated credentialing agent for the plan. So that means that they control the time frame about how quickly their practitioners move through the credentialing process, because now they are doing it on behalf of the plan. Does the plan pay them any more money? No. They're doing it for free, but in exchange, you control the time to move practitioners through the process. You typically have to follow the plan's requirements and any national credentialing process as well, national standards that have been established for credentialing. So it's a lift for some providers. There is language in Washington State provider model contracts that actually has some good protections already built into it. It says that the MCO actually, if they put somebody in a provisional status, they can't be held there more than 60 days. It can be granted one time, so they have to have a process for provisional credentialing. They also have to have a detailed description if they allow delegated credentialing, what that looks like. They have to notify providers within 15 days of a committee's decision. But my favorite one is the last bullet. The MCO shall have a process and criteria for assessing and reassessing organizational providers. The way health plans apparently have interpreted this requirement is that if you are an organization, like a behavioral health organization, that the credentialing process can just be the organization, just to ensure that you have requisite licenses from the state, that they don't have to credential individual practitioners that work there. My understanding is that Washington State Behavioral Health Council, not the Behavioral Health Council, Washington State pushed for this language specifically to basically avoid the individual practitioner credentialing efforts and activities.
They did, but we have to register behavioral health clinicians with the healthcare authority, which could take up to 90 days.
Oh, I see. Okay. So there's
So
still
you can submit a claim, and if they don't connect that to the HCA number, then, right, so we're still under the 90 days. And it's not 60 days, but it's 90.
And just for those that are listening online, the question was, we still have to, or the point was that we still have to, you still have to credential lawyer practitioners through HCA, and that takes up to 90 days to get done. So it's not pain-free, but at least that last bullet point means that, from what I understand, in regard to behavioral health providers, the plans are not individually credentialing your staff. They may require you to fill out a spreadsheet that identifies the types of staff and their levels of licensure or credential, but not actually go through the full-blown credentialing process that plans typically have. So that's been a nice savings to streamline credentialing. Utilization management, there are a lot of complaints about procedures, maximum number of visits, or getting approvals for certain types of services, different tests requiring additional authorizations before it can happen. I see a lot more relevance of behavioral health in primary care. Primary care usually is just an office visit and it's done. They're not doing the types of services that require authorization from the health plan. One thing to remember is that the determination of medical necessity is made by the plan. At the end of the day, it's their call, not your own clinician's call. It's their call whether they determine the service is medically necessary, in which they will or will not cover the service. There are some protections in Washington state law. I made the point earlier. Most of the language regarding and those provisions are in the provider, not in the contract. So when you have a lot of concerns with the provider process for authorizations, look at the plan's provider manual to see what it says and confirm that it meets the state requirements, which I think. So there are requirements in the model contract about the process plans use for utilization management decisions. And it looks like the state has done a lot to think about exactly what safeguards should be in place so that plans don't have wildly inconsistent decisions related to the same services that are covered under the Medicaid plan. So, for example, they require a certain level of licensure for the types of professionals that are making behavioral health authorization decisions. They require this decision to be peer-to-peer. So a similar type of clinician matches that the plan matches you, the one that's making the request from you, who's requesting a service, that those be peer-to-peer. You don't have an imbalanced sort of situation where you have a higher level person and they have a lower level person. So these procedures, these processes are supposed to ensure that at least there's some consistency on the decisions. What services require prior authorization? Those are supposed to be on the plan's website. Contractors shall maintain a list of all behavioral health services requiring prior authorization and submit to HCA annually and publish this list on the website. So those of you who might otherwise ask me what services require authorization, I punt to the plan. Under this requirement, it should be on the plan's website. Clearly, what services do require that authorization. Level of care guidelines. It does require the MCA to develop those level of care guidelines and the protocol. That they have to be specific to Washington state levels of care. And the good part, consistent with HCA's medical necessity criteria and comply with federal and state parity requirements. Because I've had a lot of concerns from me. People have addressed it doesn't seem to comply with our state parity laws or the federal parity laws. They should. They also should make it basically consistent with however HCA used to make their own medically necessary decisions. So the goal is typically that the HCA wants the plan to use the same protocol and determinations, same tool to reach decisions about authorization. They don't want to see a situation where the state, used one set of protocols, came up with one set of decisions, and the plans now are reaching completely different and inconsistent decisions. So most states like Washington State have required the plans to adopt the same criteria as the state did under its fee-for-service system to try to make the system somewhat compatible and consistent. New York State actually even goes further. New York State, I think, actually requires the plan to use all the algorithm level of care guidelines that the state Medicaid used historically. So it was very clear that basically the plans had to do exactly the same tool as the state service program, although still different outcomes. Sometimes there were still inconsistencies because plans would interpret those requirements somewhat differently, but that at least tried to mitigate against so many different decisions now. Contract terms. I already mentioned this in the context of value-based payment arrangements. Contract terms are important. They keep you tethered to each side. Most of the plans will propose a one-year term. Some of them propose a two-year contract term. In my view, neither is really wrong, but I would recommend a shorter contract term for the base agreement. Why? Because sometimes you don't know what can go wrong at the outset. And I think it's better to have that term come up sooner than later. So you have a short contract term, you learn as much as you can about the plan's collaboration and cooperation or denials or whatnot, and then you have the terms end sooner so that you can threaten to not renew or to terminate the contract at the end of that contract term. There's nothing wrong in my view with automatic renewal provisions. In fact, that's how they should be written. So if you say nothing, the contract should automatically roll over and renew. Because typically, the plan will want to keep you in the network, and you will probably want to keep that spigot of revenue coming into your organization. Termination, two flavors again of termination, just like on the value-based agreement. And remember that if you don't like the term, you can always try to put in a termination without cause provision to give you an exit, a way out. If you're not comfortable, then the term of the contract basically becomes the notice period. Oh, one other thing I should say about termination with cause. I often add to the list of reasons that can result in a termination for cause. So a plan has their list. That plan might not be your ideal list. Let me give you an example. The plans usually have a very long list of reasons they can terminate the contract against you. If you lose your, if you are excluded from federal health care programs, if you go bankrupt or into some kind of bankruptcy proceedings, if you lose your license, plan can terminate the agreement. And then there's nothing that's similar to that allows you to terminate the agreement for cause. So I usually just copy and paste all their provisions that they can terminate for cause, and then leave out the ones that don't make sense. Like, you're not going to go into receivership from bankruptcy because receivership is a term that's used in the context of typically, not individual providers. But if they go into, so I make the provision so that if they go into bankruptcy or receivership, you have the right to terminate. Because remember earlier, once they go into bankruptcy, you can kiss your revenue goodbye. You'll want the ability to exit the contract at that point, because otherwise they'll continue to have enrollees that come to you, new enrollees that come to you for services and you'll have financial exposures, right? Because you won't get paid on those new enrollees that come to you for services. So the moment they go in receivership, you should be able to exit the contract. If they're denied, they lose federal participation eligibility for participation healthcare program. You want to get out of it. All these things that you can think about that you anticipate, you want that on your list of reasons to allow you to get out of the contract. So usually it's mirror provision to leave a few out the door of fighting, so that it's fair to both parties. Amendments. Usually when you talk about amendments, you have to be clear in your head about whether you're talking about contractual amendments, so changes that the plan is making to their contract or exhibits, and amendments to the plan's provider manual or policies and procedures, because they are handled two different ways. Typically, plans have the unbridled ability to change their provider manual and policies and procedures whenever they want, which to some extent makes sense if they have to give you notice of the changes before you have to comply with those changes. And the reason why I know this is ask yourself whether you would like any third party to have the right to approve your internal policies and procedures. Probably not. Same is true for the plans. They don't want to have to come to every single provider to get their approval to change the plan's provider manual. That would be unworkable in practice. So what does that mean? That means anything that you want to take home to the bank and be able to rely on has to be in the contract itself, because plans will always leave themselves the right to change their provider manual as they should, provided they provide you proper advance notification before those terms become effective. It's important, it has to be in the contract. In contrast, amendments to the contract, payment exhibits, program attachments, things that are contractual in nature should be handled through more formal procedures. Here, you want to make sure that you have rights. So one type of amendment to the plan can make is that they can make changes immediately if there's been a change in regulation or statute. That makes sense, of course. The plan has to comply, you have to comply, they should have the right to notify you of the change and make the change. However, I've heard some plans play fast and loose with it. They say they got to change, and then they'll say that's the basis for them amending the contract, but it's not necessarily true. We find out they've interpreted that very broadly. So one right I write in sometimes is that they can propose the change for immediate amendment based on the regulatory change, but you have the provider to request a specific citation or statutory change that requires them to make an amendment immediately of the contract. So you can double check it, kind of verify. Auto amendment is a clause that would allow them to make a change simply by notifying you without getting your signature. It's called auto amendment because basically they provide you notice. Here's our change that we want to make. If we don't hear back from you in 30 days and you object, the change becomes effective. They don't have to run around to every single provider and get that provider to sign on. So it's considered an auto amendment. That's reasonable in my view as well, with one caveat that I'll mention when we get to the Washington state law. Written amendments have to do with them actually getting your signature on the change, which is fine. It's a little more labor intensive on their part, but that's a completely legitimate way to get approved, to get the amendment approved. Who can initiate? As I mentioned earlier, sometimes plans don't give you the right to initiate a proposed amendment. To me, that seems kind of unfair. You know, if the plan can propose an amendment on rates or something else, why can't you? So I usually change the provision so that you have the right to propose an amendment just like they do. Particularly if you're in some of these value-based payment arrangements and they're not working out well, you may have lots of reasons to propose amendments. You know, maybe they're not supplying you data that you need and you didn't know that you needed that information when you signed the contract. Now you want to amend the contract so that they have a requirement to give you specific data that you know that you need timely to do well. So you want to propose an amendment. So make sure that's reflected in the agreement. One time I was having a bit of fun, because lawyers have to have fun too, and I got on the phone with a very green attorney on the plan side, and I was negotiating the amendments clause, and I said, I proposed, you know, we should have the right to not just propose amendments, but also to do auto amendments. So we should have the same rights to you. If you have the right to auto amend, we should have the right to auto amend, meaning we just send a notice. And he said on the phone, yeah, I agree. And I put down the phone, and I said, I'm going to call you back 5 minutes. call back, we cannot possibly be allowed. We would be overrun with amendments by our providers, and we have no ability to manage those amendments and that process. It would be unworkable. And I was like, oh, kind of like how my clients think when they get all these amendments from all the various plans, that's kind of unworkable too. And I said, never mind, we will give up our right for auto amendments so long as we have the right to initiate amendments of the agreement. And I said, thank you very much. Big trouble. But one thing, I don't have a slide on this right now, but see that word notice, where the plan has to provide you notice? There's going to be a clause specifically in your contract that's the notice clause. I bet most of you have glossed over that clause many a time. You know, make sure the right names are in there, but you don't read all the other language. Take a look at that notice clause, because it says how the plans and how formally the plans have to notify you of things that they're required to do so under the contract. I've seen plans start to flip some nice language in there, where they basically don't have to provide you written notice or email notice in the clause. So let me give you an example. Usually these notice clauses dictate the form of how they provide notice. Each party must provide notice. So written notice, always kosher. You know, sometimes you have to do it by express mail or some fax service. Sometimes you can just do first class mail. That's fine. Sometimes you can do email notice to a provider. That, to me, that's also fine. If you have a specific email address that you want to associate for formal notices under the contract, by all means, give the plan an email address to transmit that notice. But what about notices that they make through their provider website or provider bulletin? Or how often are you reading those to find out changes to your contract? Probably not. And that's not where you should be learning it. The plan wants to change the contract using a passive method by putting something up on their website or sending out a transmittal to all providers. That should not be acceptable. So you want to limit their ability to use a mechanism that goes to at least one individual at your organization, in writing or electronic. Now, sometimes you might see that plans can notify, or you have to notify two people at the plan. There's two different people in which you have to send notice to. What does that mean? That means you can propose, at any time, even if you only have one, two people at your organization to provide notice. You don't have to be limited to them only notifying one person. You could say to yourself, you know what? Let's have them, we have to notify their president or provider network representative and their legal counsel to make changes. Let's put in our CEO and our CFO and put those email addresses right in the contract so that two of us are notified so that we don't get stuck in a situation where the notice comes in and then inadvertently gets ignored. We want to protect ourselves. I'm going to take out notice by provider bulletins and by changes to the website. And then one plan, I'm trying to remember if it was coordinated care. One of the plans was really interesting. They basically provided a really good notice clause, no notice by provider bulletins and whatnot, and then said at the end of the sentence, said, notwithstanding what preceded basically, plan may provide notice by website. And did all the notice terms. So these notice clauses are essential to make sure that you get adequately notified of changes that the plan is willing to make. Don't be stuck with a bad notice clause where they can send you a notice by website updates and you miss the opportunity. Because you know from the training so far, if you don't get notified of certain rights, like changes to the contract, opt out, new products that are being offered, don't get your right to opt out of certain products that don't pay you enough, you will lose out in your opportunities to shape your contractual obligations. So the notice clause isn't that sexy, but it's a critically important clause in the contract to make sure you notify the changes. So what does Washington State provide? Washington State has by far the very best protection for providers about plans, plans that want to make changes to their contract. And it applies not just to the Medicaid line of business. It's a Washington State requirement that applies to all the plans business lines. So why do I like this notice clause? Because number one, plans are obligated to provide you with at least 60 days notice for any material change that they're making to their contract. Plus, they have to flag those changes. They just have to tell you in the notice that these are material amendments to the contract that they propose to make. Third, they have to give you the opportunity to reject the proposed amendment. Now that might seem like it should be commonplace. Of course, if you object, if you object to the amendment, it should just not take effect, right? That's not how most of the plans structure their notice clauses. In most plans, auto amendment clauses, if you object to the plan's amendment, the action is that you have to terminate the entire contract. It's outrageous. Basically forces you to accept their amendment because you know if you object to it, you have to terminate the entire contract, which is not what you want. All you want is the amendment not to go into effect. In Washington state law, only state law I've seen that actually protects that right clearly and unequivocally. If you object to the notice, to the amendment, all that happens is it just does not take effect. And I guess they felt strong about it because they mentioned it almost twice basically in the regulation. The healthcare provider's rejection of the material amendment does not affect the terms of the healthcare provider's existing contract with that third-party payer. It means you object, no change to the current terms. And if the plan fails to comply with these requirements, the amendment is void. It doesn't even take effect.
So, is it possible then if you reject something, that would mean the next time, the second time there's contract negotiations, that they may not continue with you if you didn't accept particular amendment?
You're guaranteed to have the contract stay in place only for the rest of the term of that contract. And then if they wanted to recontract with you and they offered you that new term, then that could be a point of contention and they could decide not to contract with you. But so long as the initial contract is in place, it's not amended without your. So this is wonderful language, and what I do is I try to include it directly in the contract. Now, some plans are really good at it. Now, I know I think it was United Healthcare, I gave them a bad rap. But they have regulatory amendments in the exhibit in the back of their contract, and basically they upend all the terms in their base agreement. Because United typically would have unilateral right to amend their contract at any time. And they have a regulatory exhibit that basically incorporates this contractual obligation and spells it out. That they have to give you this right to object, and it has no effect on the contract. So look for clear expressions of your protections under state law and the model contract, just like that. Indemnification, I mentioned earlier, this is a quirky contractual term that basically changes the allocations of responsibilities. So imagine a situation where you are sued for malpractice by a client. You did something wrong, it goes to court. A court finds that you are, to say who gets sued. So you got sued for malpractice, and the patient also sues the plan. So the patient sues the provider, and the patient sues the plan for malpractice. Goes to court, and the court decides, you know what? The plan is 25% responsible, and you, the provider, is 75% responsible for $1 million judgment. So you fork over $750,000 to the patient, and the plan forks over $250,000. The next day, you receive a knock at the door. Knock, knock, plan calling. We're suing you for $250,000 because you indemnified us. You said that irrespective of any court judgment, you would be financially responsible for any claims that we incurred, which were caused by your negligence or willful misconduct. Here, this patient suffered an injury as a result of malpractice. That's on you. You owe us $250,000. So indemnification provisions basically change the allocations that courts decide and allow the parties to substitute and pre-decide who's responsible for what. So in this case of managed care contracts, your contract will say very clearly, you are indemnifying the plan for anything within your control and responsibility, and the plan is indemnifying you if you end up paying a judgment out because of the court judgment to somebody, but that was the plan's responsibility under the contract. So MCO should be responsible for anything that they do, and you should be responsible for anything that you do, regardless of what a court says. That's what the indemnification clause does. It pre-decides allocation. Now, there's one plan out there, I wonder if it's Molina, there's one plan out there that has a one-sided indemnification provision. You are indemnifying Molina or the plan, and the plan is not indemnifying you for anything. And every time I go with that plan, I say, why can't we make the provision fair? Can't both of us be protected by the indemnification clause? And they say no. And Molina would rather take out the entire provision, the indemnification provision entirely, than have it be bilateral. And most of my clients say, okay, that's fine. My clients would rather have no provision than have a one-sided indemnification provision in their contract. You know, that makes some sense. It just means that the parties have to rely on the court's allocation of responsibility. Any questions? I heard a few. Yeah. Get the open mic.
So, Washington state law requires the use of AIM for medical necessity, just back a few months ago. And the HCA has agreed that Molina can use Interpol, which is not AIM, but apparently is somewhat similar, to prove medical necessity. Would that be something that you would have written into our contract? Like if I go back and look, or is that going to be just something?
No. So none of the contracts I've ever seen have ever spoken to the exact entity or vendor or algorithm that is used in making these medical necessity decisions. I've never seen it. I would say that that's kind of weird that there's that inconsistency, that there's two different ones that are being used. I don't know why the state would have done that. Maybe they have their reason. I would think that you'd want to advocate the right standard to be used by all the plans, and the same one, as much as possible. I've heard conflicting things about each of these types of standards for medical decision making, but I would think that you would want the state to come out clearly about it, basically require the plans to use whatever their selected or chosen model is. What the law says, yes, so that there's compliance across the board. I think it would be very difficult to negotiate that contract by contract because, again, from the plan's perspective, they're not going to want to use different tools just for you than they use for everybody else. They want the same tool applied across the board.
Just a comment on that. We're going to be discussing that on Monday. So,
other questions? One other thing I would mention, as you can tell from this slide presentation, your state law and your model contract are the most important things to give you leverage, take issues off the table, and get you a favorable contract. And the reason why I emphasize those is that because many situations, that will be your greatest leverage point, and you won't for making changes, and at least getting those protections. I mean, it means that at least you can walk into a negotiations and know that you're already protected to some degree because of Washington state law or because of the model contract. Otherwise, you have to individually negotiate all those issues, like some providers have to do in other states. So your advocacy efforts collectively, together, to the state, whether it's through a state association or a trade association, are vital to give you those rights and protections. And with other types of provider groups who might be similarly unprotected if the state does nothing. So just because you move to managed care, some providers lose track of that. You know, they forget that, you know, even if you move from a fee-for-service system where historically you've only been advocating HCA for payment rates, and now you're in managed care, you can't give up on the advocacy. You still need to advocate to HCA to build in protections for you in the model contract, to have good, fair contracts with the MCOs. In some respects, it's even more important because now you will have multiple MCOs to negotiate with. You really need those protections built into the model contract. And it's the most way to get protections in. The more protections that you have in, the less it leads to negotiate individually with each other. Another issue that usually comes up is somebody asks, what do I do if a plan is not complying with a contract requirement from the model contract? And what I usually say to them, they ask, should I run straight to HCA, to complain? And I say, think about it strategically. If you go to HCA to complain, then you put the ball in somebody else's court. And HCA may or may not take any interest in the non-compliant. They may not view it as non-compliant, or it might just take so long to work through their bureaucratic structure. Think about what could you do to threaten to go to HCA but not actually do it in a polite, nice way. Because the plans don't want you to go to HCA and be complained about because it can harm their performance and their compliance if they're future use. So before you take the step of complaining to the state, go to the plan, try to work it out in good faith, and then if you don't reach a solution, a remedy that resolves the matter, then say to the plan, look, we've been trying for the last 30 days to work this out. We've tried hard. We're not getting anywhere. At this point, we don't really have any choice to go to the state, except for us to go to the state to try to get HCA to resolve the matter for us. But before we do, we want to give you one last shot at working. Will you do that? And they say, oh, thank you very much. And that might resolve, because that might be enough to push them over the edge, because they don't want to go to HCA, and they'll come back with something that is appealing to you to resolve the matter. So I always feel it's a better position to try to resolve it with the other party before you complain and put the ball on somebody else's court to try to resolve, because you may not like the outcome that HCA comes up with. That may not be great either. So just threaten to go to HCA for their noncompliance in the event first before you actually do so. So then you have basically two bites at the apple, not just one. Other questions that you haven't heard about, terms that you've seen in contracts that have confused you or befuddled you. I will be sending out, I will revise my slides, by the way, and send them back to include the slide of my child, as well as a citation to the Getting to Yes book, so that you have that. That must have been slipped out of my final slide deck for some reason. And that can be sent around and distributed to anybody so that you have that citation. I'm going to keep moving forward since we still have time. Let me talk a little bit about provider networks and about contracting jointly. Because one thing that has become very appealing for many providers after going through training like this is that they would rather have another agent be their entity at the table negotiating with MCOs, or have another entity that collaboratively could integrate providers and financing for providers and allow the providers to collectively take more risk than they could take alone. So I always get questions about ACOs and IPAs and how you can use them to negotiate or not. So let me start just with some definitions. ACO is this term of an accountable care organization. Basically, is this concept that providers should be jointly responsible for cost and quality outcomes. And they can do that by theoretically working together collaboratively so that you have an ACO accountable for the cost and quality of care for a defined population. The notion, I think, by the policy wonks was that maybe in the future, rather than individual providers negotiating with MCOs, we'd have clumps or groups of providers jointly contracting with MCOs, negotiating with MCOs, because now these entities would basically be competing with each other for population health outcomes and costs, with other entities also competing against each other for population outcomes and costs, basically vying to do the job better, maybe for less than their competitor, or better outcomes even if you have to pay more. And those would be, entities would be basically competing against each other for contracts with MCOs. And theoretically, the policy would say that should align the incentives in the system, because MCOs don't want to just buy services. They would love to buy services from an integrated group of providers that were aligned with the same outcomes and cost goals as they have imposed upon them by purchasers of care. So the features of the ACO, the program was first defined by federal law through the Medicare Shared Savings Program, and then now you have in some states Medicaid MCOs, Medicaid ACOs, I know I'm not here. There are a number of commercial ACOs, but they all kind of operate on the same purpose, same way. There's a group of providers, there's a separate legal entity, there's a governance process, there's management and administrative resources devoted to basically managing total cost of care, managing providers in the network, managing the quality of care delivered that's furnished by those providers, and then sharing data, performance measurement data, and then sharing a distribution of proceeds from any good contracts that they have with MCOs collectively. ACOs differ from region to region, place to place, for exactly their composition and how they look, because they were really a concept created by policy wonks in the ACA. Nobody had ever done it before. It was sort of like the Part D benefit in Medicare. Nobody ever had standalone pharmacy Part D plans until Congress created it. Same is true with ACOs. It was kind of a creation of the ACA. They didn't really exist being called as ACOs ever before. There are an awful lot of ACOs now that are in the marketplace. And now this data ends in 2014, but the 11 partners group continues to manage and monitor the total number of ACOs, and it continues to be an upward spiral. I think there's now maybe 1,400 types of ACO contracts with ACOs across the country, roughly evenly split between public insurers like Medicare and Medicaid and private commercial contracts, which is kind of interesting. You don't usually see government and commercial on par with each other, but you do have that in the world of ACOs. Are they successful? Data's all over the map. It depends who you talk to. Policy wonks are having a field day. But there are elements or evidence that some ACOs actually do work. And they do work by bringing providers together and thinking about interventions that reduce the APD visits, lengths of stay, hospitalizations in the first place, and that drives down total cost of care. So this example is the Blue Shield of California. They created 7 different ACOs across the state, basically a hospital partner with some other physician group partner, and they gave them data, and they said, go at it, try to reduce total cost of care, give them a strong financial incentive to do so, and they succeeded. And all the small words that you probably can't see from your seat are where they actually reduce cost of care. So a reduction in ER visits, inpatient bed days, inpatient admissions, inpatient rehospitalization, and that brought the total cost of care down, which is what most of the other successful ACOs have done. They've basically been able to reduce the cost of care through lower ER visits and avoidable hospitalization. So in theory, the ACAs were basically supposed to be almost patient-centered medical homes taken to a new level, with the patient-centered medical home at the center, responsible for ensuring that individual care is managed by the whole world of providers that they should interact with, and managing that care with all the different types of providers. But in actuality, most of the ACOs, or many ACOs, I should say, look like this. They were created by hospital systems that put themselves at the center, and then they brought in who they needed to make their model work. They brought in primary care because that was the primary mode for referrals into the hospital systems and to their specialists and for attribution, and everybody else kind of got either excluded or to the outside. The last study I said found behavioral health providers were only included in about 1/3 of the ACOs. So kind of off to the side, if at all. And God help you if you're a human service agency, you weren't even included in the picture, despite the bulk of the evidence that says social determinants of health have a more important impact on outcomes and cost of care than really anything else. They were completely excluded. But that's a hospital-based model of care that's very different. I would urge some caution if you are invited to participate in a hospital-based IPA or ACO, to not lose track who is really calling the shots on those kinds of arrangements and why they are in the arrangement. You have a basic disconnect or inconsistency between the financial motivations typically of a hospital and a primary care provider. Hospital, if the ACO works, they're going to see a loss in hospitalizations, fewer ER visits, and primary care providers are probably doing more work, providing more primary care and more behavioral health to keep those patients out of the inpatient facilities. So at the end of the day, if there's any savings that are generated by an MCO, you have a hard problem, because the hospital has now assumed all these losses, and they are looking for the shared savings to basically make them whole for those losses. While you, and I put all of you in the primary care bucket in this example, whether you do behavioral health or primary care or not, you've done more to keep patients out of hospital facilities, and you just want to be paid and rewarded for all that extra work that you weren't going to be doing before. So the basic kind of inconsistency. Their hospitals are fighting for dollars they gave up, essentially, and you're typically fighting for dollars that you've invested in the system that has generated the gain. Very hard to win in these situations. Hospitals typically have the bulk of control of board seats in these ACOs and IPAs, and you get the dribs and the drabs that remain. Not a very effective model, really, in my view. No less authority than Tom Scully, who ran the CMS, back when it was called the Healthcare Financing Administration. He was a hospital guy, worked as a CEO of a hospital association. He said, ACOs won't work if hospitals are in charge, because he knows hospitals just want to keep their beds filled and keep that revenue coming in. That's who their responsibilities are. So I think there's lots of different policies and studies out there, but I think that's worth a point of caution. There's many terms for provider networks that are out there, whether they're MSOs, IPAs, ACOs. I'll get to your question in a second. They are all types of provider networks. They just have different alphabet soup labels. The way I view them is that these are just provider networks. Entities that providers have decided to form or join because they think they can accomplish something together that they can't do or don't want to do individually. But don't be led by the label necessarily. Think about it as just a provider network. And then whatever goods or services that you're doing, a label might attach to that, but typically that's just a secondary label. Question?
So, Adam, just a quick question. Back to ACOs, is it unusual for provider organizations to be contracted with multiple ACOs depending on payer class?
No. So the question has to do with whether a provider can participate in multiple ACOs. And it depends on what the participation agreement with any ACO says, whether you're locked in and whether you're exclusive. So we didn't really talk about clauses and participation agreements. Many of them look like all the managed care terms that I just discussed, but they also have a fun other clause that has to do with whether you are exclusive to that one IPA or ACO. Because some of these IPAs or ACOs want to contract with all different types of insurance companies, Medicare, Medicaid, commercial. And if they want you, if you're in their ACO, to be in all their contracts that they enter with all those other payers. That's an exclusive ACO. However, not all ACOs want to be exclusive. There's many ACOs that all they do is participate in Medicaid, the Medicare Shared Savings Program. That's all they do. So they would not necessarily have an exclusivity clause, meaning that you could participate in their ACO for Medicare purposes, but you're free to participate in other ACOs for Medicaid, if Washington had a Medicaid ACO, or a commercial ACO. So there are some providers that can participate in multiple ACOs, but it depends what their participation agreements say, whether there's exclusivity or not. So the functions of provider entities or networks just depend on whatever the providers decided they wanted to do together. So for a long time, there was just a bunch of support service provider networks. Groups of providers who said, we don't want the hassle of billing. We would rather create our own company collectively to be our third-party billing agent. You know, that's an entity that could then hire the expertise that we don't have individually, billing staff that know what they're doing, and we'll have them be our billing agent. Not negotiating agent, but just billing agent for any types of services that we render. Or we want to form an HIE, or we want an entity just to do credentialing of our practitioners. So basically, it's assuming tasks that the individual provider doesn't want to do. So shared support services. That's one kind of network. Another kind of network is really forward-facing. So it's not facing back to the providers and selling services back to the providers that own them. It's actually going out in the marketplace and saying, together, we are greater than us individually. We want to sell our services or market our services collectively as a group of providers to a payer, either through marketing efforts or through facilitating managed care contracts, or in some cases, actually negotiating those contracts. So that's managed care contracting types of IPAs and ACOs. And historically, I mean, there's been some networks that have started as shared support services, and then they've gravitated over the years, and they've become managed care contracting vehicles as well for the providers that own them. It's up to the providers that own them to decide their scope of businesses, what they want to do collectively. So some of them haven't made the leap immediately to managed care. They had a few other steps along the way. And I point that out to emphasize almost the difference between being in a trade association versus being in a provider network. Trade association, if you're involved in one, you're a member. You know, you have input into it. The end. Provider networks, you own something collectively. You're business partners in the network. You're coming together for business reasons, and you might have to hold each other accountable for how you are doing if it affects each other. So managed care contracting, IPA, ACOs are tricky because now you are collectively connected, and whether you get paid by an MCO might in part depend on whether you're holding your partners in that business accountable for the outcomes that they are achieving. So it's a different kind of relationship. And the reason I mention that is because Some of these shared support services got used to holding each other accountable because they were business partners first, and they learned to trust each other before jumping into the managed care contracting space, where there were a lot more dollars at risk, but they had a track record, and they had individual relationships that supported that trust as well. Why do the antitrust laws come up at all? Why does it matter that I used to work at the DOJ? Because the antitrust laws affect collaboration between healthcare providers. We may have one set of antitrust laws in this country, but we have two competing federal agencies that enforce that law. The U.S. Department of Justice Antitrust Division and the Federal Trade Commission, which is ironic. Competing federal agencies that enforce the same antitrust laws, which means that these agencies, they compete over who has the sexiest industries and services and commodities to take actions against. And there's actually attorneys at both agencies that actually make sure that they're not stepping on each other's toes. They actually make sure they share the industries, and certain agencies take precedence over others. So, for example, if you ever read the papers and you hear about the government, federal government, coming down on pharmaceutical companies for impeding the development of a brand of generic manufacturer, is that going to be enforced by the FTC or the DOJ? The FTC. The FTC and DOJ already pre-decided that the FTC gets all pharmaceutical cases. DOJ, if there's enforcement action in the healthcare industry, insurance industry, DOJ gets the insurance industry. Providers, mostly the FTC, with a few exceptions, sometimes the DOJ steps in. So they kind of pre-decide who gets what for enforcement purposes. So the comic says, give me one good reason we shouldn't promote teamwork, the government calls it antitrust. The reason why it's funny is because the antitrust laws consider you, if you're in the same geographic area with another healthcare provider, not as collaborators in the nice sense, but as competitors. The antitrust laws applies to nonprofits just as much as they apply to for-profits, with the exception of the FTC's jurisdiction, which is a little bit muddled on the nonprofit side. But the federal antitrust law, the Sherman Act, applies to any type of entity, regardless of tax status, whether you're nonprofit or for-profit. And the antitrust law, the Sherman Act, prohibits contract combinations and conspiracies in restraint of trade, because it views anything like that as anti-competitive, likely to raise prices and cause harm to quality. Unfortunately, that's all the Sherman Act says, just that contract combinations and conspiracies in restraint of trade. And so most people are left scratching their heads trying to figure out, what the heck does that mean? If I'm a healthcare provider, for example, and I hire the sole psychiatrist in town, denying my competitor the ability to contract with that psychiatrist or employ that psychiatrist, didn't I just restrain trade? Why isn't that anti-competitive? So about 100 years ago, the Supreme Court stepped in and said, we'll clear things up. Only those contracts, combinations, and conspiracies that unreasonably restrain trade are prohibited under the Sherman Act. Not very helpful, right? Sort of like, what's unreasonable? Nobody knew. So about over 100 years, actually, of court cases, the courts have defined certain conduct which they believe violates the antitrust law, violates the Sherman Act, like price fixing. Like when the airlines agree on what fare to charge for a certain rate. When you read about that happen, that is price fixing. It doesn't matter if the fares go up or down. The fact that the airlines have collectively decided on rates for fares, that is considered per se automatically illegal under the antitrust law. Market allocation. There's been cases against hospitals that divide up their market. They say, you take one hospital, you can take the north side of town, I'll take the south side of town. You've divided or allocated the market. That's a per se violation. But also by service. You say to one hospital, I take all the deliveries, you take all, and we'll close down our cardiology unit. You do cardiology, close down your OB unit. That's allocating by service line. That's also considered a market allocation. Refusals to deal. If you all decide in the room you don't want to contract with United Healthcare, that would be a concerted refusal to deal, which would violate the antitrust law. Boycotts as well. Same sort of principle. If you all want to boycott a plan or a person or an entity, that would be considered an antitrust violation. Things that you do collectively can result in trouble. Lawyers found out this stuff the hard way. Lawyers in DC that receive cases from district court to serve indigent populations. They complained that they weren't getting paid enough money, so they told the DC district court that they would not accept any new cases until the Superior Court increased their hourly rates. What did DC Superior Court do? Sued them under the antitrust law as a concerted refusal to deal. Who won? DC Superior Court. Went right up to the Supreme Court of the United States. Don't muck around with the Superior Court. Basically, they won because that was a concerted refusal to deal. They were allowed to individually negotiate their compensation with the court, but they could not collectively decide. So one rule of thumb from a compliance perspective is you should not be talking with other providers that you ostensibly compete with about how much they're getting paid by MCOs, because that conversation could be viewed as a price-fixing arrangement. Even if you didn't jointly agree upon the price, the government can show that there's price-fixing conduct by inference. So it's as a result of that conversation that you have with each other. Both of you told the health plan, we won't accept anything less than X. The government can infer that there was a discussion between the two of you where you jointly agreed upon what price you should collectively charge them. Question?
I have a question about
Systems like hospital systems, health systems?
So, for example, Providence has multiple hospitals in their healthcare system in Washington State. Can they speak to each other because they're in the same system? They can't.
Yeah, they're basically, if I understand their structure, they're all the governance. They're all connected, right? There's maybe a parent company, and the parent company has ownership of all the hospitals that they have. So, from an antitrust perspective, they're viewed as a single entity. So what do you do if you want to be a network and do super cool activities together to improve care? If you want to lobby health plans to adopt different utilization management requirements, or you want to negotiate collectively under a value-based payment arrangement? Well, not price fixing, because you have basically a good reason to do so. The government has historically used what's called the rule of reason standard, which is sort of a balancing test. They look at the good things that can come out of the network collaboration against potential bad things, like prices going up. But that wasn't very satisfying to the healthcare industry, and so they advocated for a number of years, and in 1996, the DOJ and FTC issued what are called the Healthcare Policy Enforcement Statements, where they explained to the healthcare community what types of arrangements they would likely go after and prosecute, and which they would not. They even established a few safety zones, safe harbors as well. There's been one update since then, which is the Medicare Shared Savings Program has its own special safety zone or safe harbor for ACOs that are in the Medicare Shared Savings Program. But other than that, 1996 guidance is the only guidance out to the healthcare industry in regard to antitrust enforcement on a federal level. So what does it say? What should you know about what you can do collectively and what you can't do collectively? So I'll make this is the Adam really easy summary of these. So here, the government basically distinguishes between things you would want to do collectively that have nothing to do with fees and rates, and things that you want to do collectively that has everything to do with fees and rates reimbursement. So let me start first with the easy stuff. Joint advocacy that you might want to do that doesn't have anything to do with rates. Let's say you wanted to advocate collectively to MCOs that you want them to all adopt the same utilization management algorithm or tool that you were talking about, and you want to write them letters and say, we really recommend that you use this tool. This is the best tool. It's good for you because of this reason, and it's good for us. That would be non-fee related advocacy issues. The government thinks there could be some good results when providers jointly advocate related to non-fee information. So they said in their policy statement, this is a safe harbor, a safety zone. Even if you collect outcome data collectively in order to press your case with the MCO, that's not going to result in antitrust enforcement. We're not going to challenge that. You can collect data collectively about a particular procedure or things you want covered or suggested practice parameters to assist patients. The language is a little bit archaic. It came out in 1996. Basically, you can jointly collect data, quality data, and advocate for practice parameters or quality things collectively together without running afoul of the antitrust law. The only exception they point out is that If you tell the payer you will refuse to contract with them or terminate your contracts with them if they don't adopt your recommendations, you can't do that. That's coercive, but you can jointly advocate. I should point out here that there is already another exception for your petitioning of the state government. You can collectively advocate to HCA collectively, regardless of these safety zones. You have First Amendment rights that trump the antitrust laws, and therefore that's why trade associations are allowed to lobby the government. That's why you're individually allowed to lobby the government. That is always allowed. The thing that's different that I'm talking about is when you advocate to MCOs. This is not the government. And that's why these safety zones and these safe harbors are important. So non-fee related information, feel free to jointly collect outcome data, quality data, and advocate collectively for better policies from the health plan, so long as you don't coerce the health plans to adopt your recommendations. What about fee related information? Let's say you want to collect information from each other about what your payment rates are. And you want to provide information to each other about what different payers are paying in the market for services. Maybe you even want to use some of this information to tell the health plan, this is what the going rate is for a particular service. Can you collectively engage in the sharing and collection of fee-related information? Sometimes, yes. So the government actually does think it's important, in this case, for how, that this information does have some value, even though it raises antitrust concerns. Let me give you an easy example. Do you think it matters to Crest how much AIM charges for their toothpaste? Absolutely. Because in order to price their toothpaste competitively, they have to know what other providers what other competitors are pricing for their toothpaste. So there is a benefit from a competition perspective for providers knowing what other providers are getting paid. The government just says you can't collectively decide what those rates are. So the government created a safety zone that would allow third parties to collect payment information from competing providers, collect that information, and then publish that information collectively. So you could hire a consultant, essentially, to collect fee-related information from your contract, so long as it wasn't data that was within the last 3 months. So you'd have to say in your surveys, tell me what you were paid 6 months ago by each payer. That information could be collected. And then when you publish the data, you wouldn't be able to reveal particular providers and disclose the identities of those providers. You would have to list it by quartile. This is what the paid at 50th percentile, 75th percentile, and 99th percentile, and that information would be shared, collect individually to each of the providers in the network. But the network or the providers participating would not be able to talk about that, should not talk about that collectively. Each provider would have to use that information themselves. There's actually a similar, and then you couldn't use that data to collectively negotiate on rates. You would have to use it yourself to decide the amount that you want to charge. There's a similar safety zone for the sharing of cost or price information. So for example, let's say you wanted to share with your peers what you paid different types of clinicians at your organization. It wouldn't be a good idea to have those conversations directly, but you could participate in a salary survey. And many organizations do participate in salary surveys, and they're used to ensure that you are paying market level rates to different types of employees. And basically the requirements are the same, collected by a third party, information is at least 3 months old, and no practitioners, providers individually identified in the data. So what do you do? Let's say you want to negotiate managed care contracts, and you want to negotiate fees for service contracts collectively with payers. Can you do that? No. If you've been listening closely, you generally can't collectively negotiate fee for service contracts. That would be agreeing upon specific prices that would be charged to payers. But the answer can change. The answer changes if you're a network that's not composed of competitors. There was a big, there's a big Midwestern state, and their providers came to me and they said, we want to form a network, negotiate fee for service contracts, but we are all in separate counties, not even touching contiguous counties, separate parts of the state. Can we jointly negotiate? The answer is clearly yes. There's no loss of competition because there was never competition between them or among them to begin with. So providers and networks where there's no competitors, they can freely negotiate fee for service contracts. Providers in financially integrated contracts, I'll explain what that term means, can negotiate collectively. Clinically integrated contracts, a network, defined as the DOJ and FTC define clinical integration, may be allowed to negotiate in contracts. And ACOs that are in the Medicare Shared Savings Program can negotiate contracts collectively on the commercial side because there's a special safety zone that protects them. So let me talk about financial integration and well, we talk about this and then financial and then clinical integration. So you are probably going to fall into this safety zone, this statement in the enforcement statement, because if you join with another type of provider, would be considered multi-provider network, different types of providers. The only safety zone that the DOJ and FTC created for providers that want to contract together are physician organizations. Anything else is considered a different type of provider. So whether you are an FQHC joining with other FQHCs or FQHCs joining with behavioral health providers, you are considered a multi-provider network. And the FTC and DOJ basically punted. They said, that's interesting, it can present antitrust issues, but we can't establish a safety zone for you. Instead, you're going to be evaluated under the rule of reason, and whether you're clinically integrated, financially integrated, that would have a bearing on whether we approve of the situation or not. So what's that mean? What does it mean for a network to have substantial financial risk? I thought your question actually earlier was going to be about Providence. They formed their own network, and then they contracted with other private doctors that they don't know whether they could negotiate on their behalf. Because there's a number of hospital and health systems that have formed IPAs and ACOs and negotiate on behalf of all the providers in the network. And I get these questions all the time. How can they do that under the antitrust laws? Doesn't it violate the antitrust laws for them to negotiate those contracts collectively? And I say back to them, I bet they have capitation agreements. Because if they are capitated at the network level, they can negotiate the agreement with the payer. And then they can turn around and pay all the providers in the network fee for service. Because under the antitrust law, that's considered substantial financial risk-taking by the providers in the network. Let me break that down to make that even easier to understand. I bet you have clinicians that you employ in your organizations. Why is it possible for you as an entity to negotiate their compensation with payers? Because you are financially integrated, essentially, at your agency organization level. The reason why you can negotiate fee-for-service rates with the payer is because those practitioners that are employed by you are basically taking financial risk by joining you, and they are hoping and praying that you will generate enough revenue that will cover their salaries, right? It's almost like they are in a financially integrated arrangement. Their futures are tied to how well you do in negotiating compensation from a payer. Same thing is true on the larger level with networks. Providers that basically tie their fortunes with each other for the network to negotiate adequate capitated payments from a payer, the network can now negotiate those capitated amounts. But the providers know that if the payer doesn't do, the network doesn't negotiate well enough, there won't be enough dollars in the kitty to pay all their claims at the end of the day. So those are considered financially integrated networks. And that's why networks or big health systems, which usually have capitated arrangements with payers, can negotiate those terms. And then pay those providers individually, usually by fee for service. The antitrust enforcement agencies don't think capitation has to be the only model, but any model essentially where the network is taking financial risk collectively for the providers in it, would constitute substantial financial risk sharing and be financially integrated. When the agencies evaluate networks that take on this kind of financial risk, clinically integrated, they have a standard process that they use to evaluate whether there's more upside than downside. And so for financial integration, what they want to make sure is that there's a very strong incentive for those providers to work together in managing the total cost of care. And I've not seen any enforcement actions against any network that is paid on a financial risk-sharing basis, where they get capitation and the government has said, no, that doesn't incentivize enough collaboration. It always does, because all the providers want to get paid that are in that network. So of course, the network has a very strong incentive to manage the total cost of care so that they all can pay all the providers in the network. Otherwise, providers wouldn't stick around in the network if they didn't think that the network was going to cover all their claims. They define the marketplace, they figure out who's in the market, they look at any potential upside and downside, and whether there's quality or cost. Can a network engage in other contracting efforts with MCOs that have nothing to do with basically payment for services? Yeah, there are a number of networks that get delegated credentialing activities and they get paid. Or do care management get paid on a population basis, PMPM, or care coordination and care management? They might do quality improvement tasks or utilization review and negotiate a rate, a payment rate with payers. They can negotiate that payment rate because usually the network is the one at risk, essentially. They have the staff and the resources, and they are at risk if they don't negotiate a high enough level of compensation, but they'll go out of business. So they can negotiate those terms unrelated to providing healthcare services. What about value-based arrangements? Let's say you want to have a network, and the network doesn't want to negotiate base reimbursement. They say to all the providers in the network, keep your contract. They're your business. They're your problem. But let's come together collectively and negotiate a value-based contract with a payer, where now the network would maybe be under shared savings or shared risk or pay for performance. But we only want to negotiate the value-based component. We're not negotiating your base reimbursement. Could the network do that? Well, let's run through the legal test. Do the network members share substantial financial risk under the proposed arrangement? If the network providers jointly earn the incentive based on group performance, not individual performance, but group performance of the network as a whole, then the network can negotiate the compensation that applies. So if the network is jointly held accountable for how well they do on the HEDIS measures, and then the plan decides based on their performance, we're going to pay money to the network, then the network can then negotiate the compensation that pay for performance program. If the network decides to take upside or downside risk and figures out what percentage it gets, wants to negotiate what percentage of savings it gets with a payer, they can jointly negotiate those terms because all the providers are basically going to be stuck with that contract collectively and bear the financial risk. Maybe the network owes money back, or maybe it earns something, but it's based on their collective performance. So there's a number of networks that are formed, like in New York State, where the network is not negotiating base contracts with the MCOs. In fact, they tell all the providers, you are responsible for your base agreements with the MCOs. You won't be eligible to participate in our value-based arrangements unless you have a base contract with each of these MCOs. And then if you do, you can come into our network. We'll negotiate value-based incentive compensation, basically on your behalf. We'll have to win it or lose it by ourselves, and we will negotiate and manage that line of business for you. So that's been appealing for a number of providers because they didn't want to give up their contract or the ability to negotiate their contract, but they wanted to participate in value-based arrangements, but they didn't have the capacity, resources, or infrastructure to do well in those contracts on their own. But that would be a valid model under the antitrust law because now the networks are taking financial risk together. So they've kind of split it. They have their own contracts for base reimbursement, and they use network for value-based arrangements, basically for incentive compensation on top. There are some networks that have proposed that they are clinically integrated networks, and therefore they should be able to negotiate fee-for-service contracts with payers because they are clinically integrated. The DOJ and the FTC left this door open, issued the 1996 policy statement as a potential window, and there are some networks out there that went to the FTC in particular and said, this is what we propose to do for integration. Can we negotiate fee-for-service contracts? The argument being, yes, we're setting fee-for-service rates. That's the downside. But the upside is we have a great clinical integration program where we're likely to improve quality, hit scores, do well, and save costs for our healthcare system. And the DOJ and the FTC primarily basically said yes, in many cases, to the IPAs that wrote it. So the slides actually have 4 or 5 examples of what these clinically integrated networks had to do, have clinical practice guidelines, hire staff, penalize providers that did not follow those protocols. And online you can actually see all the FTC advisory opinions for these different types of networks. Sometimes the networks are composed of physicians in hospitals, other times they're just hospitals, or other times they're just physicians, and these entities, once blessed, were allowed to negotiate these contracts collectively according to under these arrangements. Can providers negotiate base reimbursement rates in the service schedule? Question is, do the networks share substantial financial risk? If it's fee-for-service rates, that's not capitation, that's not financial risk collectively, so no. If the entities are clinically integrated, then maybe, but you should get an advisory opinion to make sure that you have the DOJ or FTC's blessing that you can collectively negotiate. In my experience, in my view is that if you want to engage in clinical integration activities, you might be better becoming financially integrated, at least in regard to incentives, so that you can negotiate collectively. You probably will need to be clinically integrated to do well under any of those arrangements. If you're in a Medicare ACO, these ACOs can jointly negotiate with commercial payers for service rates. That might strike you as odd. It did me initially. I was like, why is the government allowing fee-for-service contracts to be jointly negotiated for these ACOs that are not financially integrated or clinically integrated? And I think the answer is that the FTC and DOJ viewed CMS's regulatory requirements for any of these Medicare ACOs as sufficiently integrating the providers, and so it permits them to negotiate commercial contracts as a result. If you're not integrated clinically or financially, are you out of luck? Mostly. You cannot negotiate contracts if you're not clinically or financially integrated. Instead, you can only facilitate contracts through what's called the messenger model. The messenger model basically means that you have a group of providers, they formed a network, the payers can offer contracts to the network has to individually convey those offers down to each provider in the network, which has to individually decide whether they accept those terms. That's communicated back to the network, who in turn communicates that back to the payer. There's going to be no negotiation. So as you can tell from my expression, it's a little bit laborious. It doesn't get the network very much because they're not negotiating, but it can get some of those providers contracts that they might not have had an opportunity to get and be left out of, because the network can certainly market the network collectively, and so it can result in some new contracts for some providers in the network. But there's a lot of costs associated with forming this kind of network and not a lot of gain in the process. It's also risky. There's a number of these networks that profess to be operating the messenger model, but actually negotiated contracts collectively with payers, and they got put out of business by folks like me when I was at the DOJ. We ran around the country putting out IPAs that claimed they were operating under the messenger model, but were not. They were actually collectively negotiating contracts. So I'm not a huge fan of this model because compliance is difficult. We put it like that. I already pointed out that you can actually do both, but you can do both within a network. Networks can be composed of providers. The network can negotiate base reimbursement if it operates under the messenger model, and then just negotiates the incentive part, compensation, that it wants to negotiate. They can split it up that way as well. So they have a single contract with an MCO, but they're not negotiating base reimbursement, they're only negotiating incentives. But that would still be law. Final thoughts is that, as many of you probably have experienced or know, grant-funded programs are not great for generating margin to invest in your resources or facilities. In fact, you can't profit off of grant-funded programs. And I think it's left a huge part of our health and human service organizations, agency network underfunded for years because it's been difficult to raise capital for expansion and for investment. MCO contracts offer the ability to generate fee revenue that can be put back into whatever uses of your agency that you want, but it's hard to get it. It's hard to get good contracts. It's hard to generate sufficient revenue from those circumstances. Hopefully, the notion of value-based payment will actually open the doors so that providers are not simply reimbursed for the services that they render, because that's good, but that's not the whole shebang. The whole shebang is that if you are a primary behavioral health provider that is providing value back to the system, to payers by reducing total cost of care, to states who have lower costs of purchasing Medicaid-funded services, well, hopefully it tees you up to actually benefit basically be compensated for the value that you are giving back to the system to generate additional incentive revenue. I think it's very hard for individual providers to do this, to engage in value-based payment methodologies and take downside risk, upside gain, capitation for a broad suite of services. So I encourage you to continue collaborations with each other to make those possible. And think about ways you can collaborate either within a network or even outside of network together so that you can reap some of the benefits of value-based payment arrangements so that it continues to draw in funds. Because I think at some point, the ACHs do go away. You know, that money will be lost, that money that you have access to, and you'll have to find a way to make up for it. And hopefully the MCO revenue stream at that point can basically compensate for that loss and put money back into the providers that make the savings possible and provide the most value into the system. And they have been underfunded historically. So I would continue to try to find arrangements for collaborations in that manner. That's the last slide. So I wish you good luck in your managed care contracting. Thank you for staying to the end. So 4 p.m. local time, 7 p.m. Eastern time. I only do future consultations after this time with a beer in my hand. I'm happy to stick around for a few minutes if you have questions. But
I just have one. How do we hire you?
That's an after the fact question. That's an after.
I would assume there are more of you around to hire.
There's only one of me, but yes.
If I wanted to get model contracts in multiple states, where would I look for that?
Model contracts, like other model contracts to compare?
Like any sort of model contract.
You have to go online. Sometimes you have to fish around for it. Some state banking agencies go online, other states hide them. Sometimes they're stuck in procurement divisions and stuff. So you might have to root around to find some of the states. There's really one state that you want that you can't find, you have to do a freedom of information request to get it.
Okay, thank you. Adam, you are right. Well,
Thank you.
okay. Drive some safely, everybody.